would have been excluded from being able to vote. The Legislative Council, as it was then, would have had a mix of ex-officio officials that came as part of our colonial status and who were automatically a part of the executive and of the council that made laws, and the Electoral would also have had members of our community who would have been considered to be assisting in the governance and the management of our country. But in 1952, following the general movement that would have been initiated in the 1930s by the Workers' League, and we would have learned of the Buckley's riots, the 1930s, the presence of the Moyne Commission that would have come in 1938 to look at the conditions of life in our country, where many of our people lived in the substandard conditions. Recommendations of the Moyne Commission and others would have led to a gradual and initial movement to try and better the lives of our people. And when in 1952 we had our first government that would have been elected in the House of Assembly, albeit in a colonial status at the time, we would have begun that long movement to where we are today in terms of the process of developing our laws, or developing our practices, and so forth. The National Assembly Elections Act is an important one, Mr. Speaker, in that regard. And the amendment made today, as the Honourable Mover of the Bill, the Honourable Prime Minister, Member for Number 7, had said, is a first step under this administration. We will be coming back to this Honourable House over the next weeks, months, term, to constantly try and improve it. Because there have been a number of areas where the bill, the act, has not been right. The conduct of elections have been observed by organizations in which we have an important relationship, the Commonwealth, the Organization of American States, CARICOM. And they have sent observer missions, as has reproduced local observer teams. And over the years, these different missions have indicated that whereas for the most part, our elections were conducted in a free and fair manner, for the most part, our people had exercised their franchise, that there were areas where we could improve. We have heard of such things as campaign finance that need to be looked at. We have heard of other issues. We ourselves become frustrated and uncomfortable with the length of time the counts have been had in recent elections to announce winners in various constituencies. And of course, we remember in 2015 the debacle in which we did not even announce winners in certain constituencies, certain seats, and that was problematic. What we do today has to deal with voter registration. voter registration is at the heart of any electoral system. Who is able to vote? Who qualifies to vote? And that is what this bill is, the first step. We have a number of people here in our country, we can refer to them as both citizens and residents. They're all residents. But all residents do not have a right, a constitutional right or any right, to feel that they must vote, to feel that they have to be registered to vote. And this starts with our Constitution, because in section 29 of the Constitution of St. Kitts and Nevis, it speaks to the election of a representative, and in subsection 2, it says this: every Commonwealth citizen of the age of 18 years or upwards who possesses such qualifications relating to residence or domicile in St. Christopher and Nevis, and here comes the part, as Parliament may prescribe, as we are doing today, shall, unless he is disqualified by Parliament from registration as such, be entitled to be registered as a voter for the purpose of electing representatives in one, but not more than one, constituency, in accordance with the provisions of any law in that behalf, and no other person may be registered as such. So, Mr. Speaker, the pool of people who can register to vote in our elections are Commonwealth citizens. If you're not a Commonwealth citizen, you're not entitled, you're not qualified to vote as the law stands today. All Kittitians and Nevisians are Commonwealth citizens by nature of being citizens of St. Kitts and Nevis, so they're automatically qualified. Who are the other Commonwealth citizens who qualify? And those are members of countries that were part of the British involvement around the world, where they went and they established themselves in countries in Africa, in Asia, in North America, in the Caribbean and elsewhere, in the Pacific. And part of that colonial, as it was then, relationship, and as countries became independent and graduated, as it was, into other status, we then formed the organization, the British Commonwealth, of which Queen Elizabeth is regarded as the head of that organization. The Commonwealth then is based in a colonial status. It has to do with the fact that we are former British colonies. Some of our neighbors in the Caribbean have moved away from that Commonwealth status. It doesn't mean that they don't have relations with Britain or anything of that nature, but they may want to change that relationship. But some of these countries in the Commonwealth, as we become independent, are far-flung and have no other connection with us. For instance, Tonga,
yes.
Fiji, where are they? Anybody ever hear about Vanuatu?
Yes.
You know, Vanuatu, it's a nice name, but where is it? You know, somewhere far-flung. They have nothing to do with us.
Yes.
And they can come here on our current arrangement and spend 12 months, and they have a right, according to our Constitution and law, to be registered to vote. But Everybody in St. Kitts and Nevis know where Santo Domingo is. They can't come here for 12 months and register to vote. They do not have the right under our Constitution. Haiti, who is part of CARICOM, does not have that right. These are people, our neighbors in the Caribbean, who we have gone there, had children and come back. Those are citizens and let's avoid.
Be careful.
But the point is, there is a distinction when we speak of Commonwealth.
Yes, there is.
In our relationships.
And it's real.
You know?
Self-evident.
From the 1970s, from the late 60s and 1970s, St. Kitts and Nevis, along with other states in the OECS, today's OECS, would have become an associated state with Great Britain and shifted and moved away a bit. And then we were part of the wider English-speaking British legacy and became part of CARIFTA, the Caribbean Free Trade Association. And that is our evolution. And then became the Treaty of Bastille, right here in St. Kitts, where OECS states signed, as it was, to free movement in our islands. St. Lucia, Grenada. They come here for 6 months and they don't need to show the passport and all that. It's an extension. That's free movement. We are also signatory to the Treaty of Chaguaramas, which is a town in northeastern and northwestern Trinidad, that formed CARICOM, Caribbean Community, that gives us free movement of people, trade, free trade in goods and services. These are people who we relate to.
Yes.
And think about it. Britain, who we have had that historical relationship, they have been part of the European Union that had the same freedom of movement, free movement of goods and services. In essence, Britain was closer to our European neighbors than she was to us after a while. And so there is a distinction in terms of who we think and who we have an affinity to be a part of our mix here in St. Kitts and Nevis. Again, the Constitution is clear. All Commonwealth citizens, once they live here for 12 months, or once they are here, all Commonwealth citizens, the Constitution says how long, can be registered to vote. So we can't tell them no. What it does say in the Constitution, Parliament can prescribe how long and how they can be qualified. And so the simple bill we do today, the simple step, is to say that there should be a distinction between our Caribbean Commonwealth neighbors and those who are in far-flung reaches of this world who don't have that connection with us, who maybe after 12 months, 16 months, they pick up and go, but they could say what government they want here. Yes. And so this is a small step, but a first step in qualification. We said that our CARICOM, our Caribbean Commonwealth neighbors should continue to get qualification once they live here after 12 months. And I interject at this point the concept of residence, when they reside here, the resident in St. Kitts and Nevis. And the concept of residence is an important concept. We say that if you come from an African nation or Asian nation, and other crimes that you should spend a little longer to show that you have become acclimatized to us here in the Caribbean and to our people, and you understand our culture, our mores, our laws, what we do. And we say 3 years is what we recommend. Mr. Speaker, I'd also want to suggest that at some point in time, our people will have to address the idea of other residents. And if many of them own businesses, many of them make contributions to our country in a number of ways, and I've been here for many years. And if they're resident in our country, how do we get them to have certain responsibilities and obligations? And should we consider that they too should? You note, Mr. Speaker, that on the order paper for first reading today is an amendment as well in terms of citizenship, that those non-Commonwealth people can become citizens. We will come back and debate that. We'll debate how long they should reside here. At the moment, if somebody wants to be a citizen, they have to be here for 14 years. 14 years. We're the only Commonwealth Caribbean country that has such an extensive period of time. Others of them, and only for Commonwealth. Okay? Most others, if not all others, at least 7 years. Some are 5 years. And so, an alternative to those who may not be non-Commonwealth can be satisfied through this citizenship process. If you're really committed to St. Kitts and Nevis, you love it here, you have been here X number of years, and want to participate fully, you become a citizen. And so you could also register to vote. So the concept is qualification in terms of residents of those who come from outside to live with us. Mr. Speaker, it's a very simple bill. So that is the first part of the bill. The second part of the bill, Mr. Speaker, speaks again to a concept of residence. That if I live in Molyneux, I should register to vote in Molyneux and not seek to want to go in Challengers to unseat Lindsey Grant. That don't make no sense. I reside in Molyneux and I should register to vote where I live. It's a principle of the National Assembly Elections Act that speaks to the concept of residence. Let us not get away from it. We have to register where we live. And I hear a concept that if I have 5 boyfriends in different parts of the country, I could decide which one of them I want to register with. You live somewhere. I don't know people got 5 boyfriends who got 5 residences. If you reside somewhere, you live somewhere, it can be established, you know where you live. Some of us, of course, have apartments in Frigate Bay or on 4th Street or in other areas around the country. But we know where we're from and where we live. We know where we live. Residents, you must register to vote. You must register to vote where you live. You know where you live?
You know where you live. Others know where they live.
Oh, I see.
You can't determine.
I can't determine that. Well, I must say, Mr. Speaker, I'm glad that the leader of the opposition has raised this, because this has been, we have been talking about this, for 25 years. 25 years, this has been going back and forth. And let's put it on the table.
The law allows you for that.
Let us put it on the table. The law allows you for that. The law allows for that. But we can manipulate the law.
No.
And we know that for a lot of years, that in areas where the Labour Party has felt they're not as strong as in other areas. It doesn't matter who brings it. You know what I mean? It is what it is. If the law is flawed, it needs improving and correcting. It needs changing.
All of a sudden you said the Labour Party?
But I'm talking about that because there was a policy that if it is, I can register you somewhere else and it can't be found out. Fine. And the idea is that to make our democracy proper and requisite, that we should adhere to the basic principle. If I live in Greenland and my roads are not being fixed, and I have problems with my electricity and water, or my daughter wants help, I should be able to go to my representative for that area, who knows me, knows of my problems, for assistance. That's what representative democracy is about. That those who live in a particular area should be able to approach their representative to make representation to public services and other types of things for their assistance. Sometimes we go by the pastor, sometimes we get a teacher, but the elected representative, his or her responsibility is to see what the constituents who ostensibly vote for you require, and you respond to them by making representation on their behalf. That's representative democracy. And I can see how, if I live in Challengers and somebody live in Maligno, because the mother live in Challengers next to me, they could come and decide who should represent me in Challengers. It is about representative democracy. You register where you reside. I think that's a very simple concept. What is ordinary residence? Yeah? And that is defined in the law. And not just the law, the statute. Because this has gone to the court, the High Court. It has gone to the Court of Appeal and has been interpreted in our courts, Mr. Speaker. There's a case of Lauren James and Dudley Williams that has gone all the way up to the Supreme Court, where Court of Appeal Justice Barrow, as he was then, was very clear. It is not sufficient to say, I know that individual does not live here. But I know them. And I know where they live, over there. And the court has said, if that's the case, that person should not be on the register here. They should be removed. That is the law of the land. That is the common law, interpreted by the Court of Appeal. And there is a procedure for these things in the National Assembly Elections Act. When somebody registers to vote, Mr. Speaker, and they do so in a calendar month, October, any day in October, the law provides in section, I think it's 43, that the following month, the 15th of the subsequent month, so the 15th of November, a list of all those who registered for this constituency should be published in a public place inside that constituency, that polling division. That is the law. There are provisions within the law, as section 35, I think it is, to allow, 35, to allow each political party to appoint scrutineers. Each political party shall be entitled to nominate, in accordance with the prescribed form, one person who is qualified as a voter for appointment as scrutineer in respect of each polling division, and the person so nominated shall be appointed accordingly by the registration officer for the constituency in which a polling division is situated. And the scrutineers attend at the office every month. A lot of them don't, but there are agents who go to that office to collect the list, to scrutinize it. Does this person really live in this polling division, in this constituency? Or is it the visiting the boyfriend I want to register? I think what it was, MRI, multiple relationship individuals, was the phrase I heard today. First time I hear that. First time I hear that, yeah.
Oh, it's not only medical, it's social.
It's social as well. I'm sorry, but I learn something new every day. Multiple relationship individuals.
Actually,
You would that one too,
yeah,
Mr. Speaker?
I couldn't remember what I was for.
Yeah, multiple relationship individuals. You know?
Individual, yes.
And the issue really was that because I deal with a lot of men, I could find one of them to register with. Something wrong with that.
That's not what she said. That's not
And that's what I didn't say anybody said that.
Yeah. Very wrong.
But you have multiple relationships. You got multiple relationships. And I should be able to choose where I want to register. That's what was said.
It's a ridiculous
You know what I mean? And you could register to reside you can register where you do not reside.
Yeah.
Something can be wrong with that.
Must be.
That is why people have been clamoring for electoral reform.
Yes.
That's what I mean by electoral reform.
The manipulation.
Register where you live to vote. Don't move up and down.
Simple principle.
Simple principle.
Yes.
Let me move 10, 20 people so I get an unfair advantage here to pick somebody who the people don't want in that constituency. Something wrong.
That's what you are doing a lot in the last election, yeah?
You're there for 20-something years.
That's what you did,
You understand that?
You are so bored, you don't boasting about it here today.
But you went up in Bronx in 95 and said that. You said that up in the Bronx in 1995.
Yes, it's
That's what you say. If people from up there could come and register and vote and go back, why young people in St. Kitts can't vote anywhere they want? You understand?
The law allows for that.
When we say we want to tighten the law,
You're changing the law.
we want to tighten it up. People must register where they reside. That is the concept. And so therefore, The second part of this simple bill, Mr. Speaker, is to look at this concept of if you had to change your residence. So in other words, I live in Greenlands. I'm properly registered in Greenlands. I've lived there. I work there. I play cricket, football. I'm there. My neighbors know me. But then I move to Bird Rock or Frigate Bay or Camps. Do I keep going back to Greenlands to register to vote? If I move out of the constituency, do I keep going back and keep going back and keep going back? Or do I now live in a new constituency? The principle is the same. You need to register where you reside.
Yes.
And we call upon all citizens to voluntarily do so. It doesn't need anything about penalizing you. If we are proper citizens, we understand the concept.
Yes.
And we voluntarily. Don't have to wait for an election. Move and apply to have my name transferred to where I now live. And you want to come with a day after, a day before, the principle is what it is. And as law-abiding citizens, we should do what is right. We should follow the rule and do what is right. That's what this is. So, the law provides, Mr. Speaker, current law had provided for, that if you move, you shall remain qualified until you qualify for another constituency. But you don't say how you should qualify the other thing. This is the opposite is right. So, I use the law as it is, as the leader of the opposition said. And I don't have to move. Don't have to move. I keep going back. We say, or we are hoping to say, that after 6 months is an adequate time to consider going and visiting the electoral office and apply to move your name, so that people register to vote where they live. That is the principle. It's a very simple principle. The mechanics will work itself out in objection hearings and so forth. You know, Mr. Speaker, today, His Lordship, Justice Ward, handed down a judgment. That is important because the senator opposite spoke in a presentation, interjected quite a number of times about COVID. State of emergency in place because of COVID. Dangerous pandemic.
Yes.
And the government trying its best to protect the people.
Yes.
They pass regulations, a lot of regulations.
Yes.
Tight, and you relax them, so we have people adjust to different types of behavior. And over time, we understand that the wearing of a mask is important to protect ourselves. We don't have it, maybe, so we're not wanting to give it to anybody else. But you don't know who you're going to put upon when you walk down the street.
True.
Who going to breathe in your face and they got it. They might not even know they got it. So wearing of mask is for your own protection and that of your family. And it has been put into regulations to help us adjust to behaviors. Today, and other non-pharmaceutical protocols were put into regulations to help our country cope with this pandemic that is causing havoc in some of the other places in this world. But I want to make the point, the way I talk about that in passing, is to say that this case was filed or served on the governing authorities on nomination day. not before the dissolution of Parliament or anything like that, so that if it was not proper, something we could have done in Parliament. But when it was nomination day, Friday to say something wrong with the state of emergency. That somehow, sorry to call his name in this way, Timothy Harris trying a smart thing. The member for number 7.
And he's here to the building.
Yeah? He wanted to use state of emergency to beat Douglas again. Eh? He beat you once, he beat you twice, man. He beat you twice. You know? He beat you again. And he's trying a smartness with the state of emergency. And somehow the police unfair to the Labour Party. Well, the judge has put that to rest today.
Yes.
Put that to rest today.
Rejected it.
The state of emergency was proper.
Yes, it was.
But why raise it, Mr. Speaker? Two other claims, were filed at the same time. The day before election, the day before the election day, we had to go to court to answer to two other claims. It happened so that the people didn't even understand it. They went slip, whoop, whoop, whoop. One of them was brought, I take it by supporters of the Labour Party, two supporters, who say they want to put on 184 names on the register of Constitution number 4. That's the day before, you know, to vote in Constitution number 4.
You see that?
184 names.
You see that?
Voter registration. Voter registration. There's something wrong with the voters list. All these years, all these years, as I said, that it popped in my head, why now? We wash it and urgency.
Well, you know, you have the principle.
But that was last minute. That was last minute. That they want the judge to put on 184 names on the list. And there is concern about the voter registration process. And the claim was that some people may not have gotten notice. They may have gotten notice and pretend they didn't get and don't turn up. And when a hearing is held to hear the facts of whether I live with my boyfriend or my mother, or I live in Molyneux or Challengers, they don't turn up. And so therefore what happens? A manipulation of the voters register. This is what electoral reform is, you know, to try our best to put in place ways in which we can get all of us to be honest and do the right thing. Do the honest and right thing to register to vote where we live. And not go where we feel we could help somebody by padding the list somewhere else. That is what the first step is. And we're going to keep coming back to it, because we think we should get it right.
Yes.
Register to vote where you live. And so, we say, I should just mention, Mr. Speaker, that that claim didn't go anywhere. It didn't go anywhere. There is and has been an issue, because I remember it. I was involved in a matter many years ago. We have 115 people we had to take to an objection hearing. Same old road. Anyway, I won't go into that. But that was a question of service. If I say I live in Durant Avenue. I live in Durant Avenue. 50 people live in Durant Avenue. And the PAM agents decide, I don't know these people. So they object to the registration officer, who establishes within 10 days of the publication of the list, on the 15th of November, you have until the 24th of November to object to somebody who should not be there. If I'm in Challengers and I know somebody who live in Molyneux, register to vote in Challengers, and I see the publication come out, I have 10 days to say, you don't live here, so I object to you. And the registration officer will then send a notice by registered mail to Challengers. And guess what? In Challengers, nobody know who names up, because you really live in Molyneux. And so it's returned back to the office. They don't get notice, so they don't turn up.
I see how Challengers and Molyneux came in now.
Do you understand?
Yes, it's a scheme.
You understand? And that happens. So that if we don't get notice, what happened? And so, what we have had to do for the last 2-3 years is that we get the High Court bailiff, the bailiffs, to serve the people in Molyneux where they really live.
We don't get trouble over there.
You don't get no trouble over there. Okay? But that's really the issue. That the system, the law, has to work properly, and we have to find mechanisms to do it. Make sure that you get served and you turn up for the objection hearing with a registration officer. And what the registration officers must do is, if the evidence is there, and I say evidence, let me explain what I mean by that. So you get served. So, but I ain't going. Because if I don't turn up, we can't have the hearing. But the bailiff come and file an affidavit to say, I served so-and-so on such and such a date, at such and such a time, and such and such a place. So they get it and gives that to the registration officer. So they can't say they ain't get served. And at the hearing, evidence is presented by a neighbor in Molyneux who, yes, people than you. They know what time in the morning to catch a bus to go to work up Jarrow. They know who your brother and sister be and who your mother be. They know your details. All it needs is get 2 or 3 people to give you an affidavit, short affidavit, 1 page. I know so-and-so, and who are prepared to come to the hearing. So there's evidence that you live in Molyneux. You get evidence that you don't live in Challengers too. So you can't say because my boyfriend lived there, that's where you live. You register to vote where you live. Residence. And the idea is that after 2 years I build a house and I move, and 3 years, or after 10 years, I like Timothy Harris, so I'm going back and vote in Tabernacle every time. That ain't right. You got to go where you now live. Move your name. And we say 6 months. Should be the start. I don't think you have registration officers going home peeping in every window to see if you're there 6 months. Because the common law is that after that 4th monthly list, that time frame has passed. You can't go 2 months later and say, oh, I find it. But, and here's a good one. The law provides that once a year, the 31st of January, every year, an annual register is printed. And that annual register is the defining register for voting in our country. And any voter in a constituency can object to someone who is on that list. A voter who had made an application and is properly supposed to be on the list can also claim at an objection hearing. So it's not just to take off people or to solve people that who register with a live, but if you register properly, and I should be on the list, who take off my name? My name's supposed to be on the register. My name's supposed to be on the register, so I can make that claim. And hear it up. If there's a hearing and a decision is made one way or the other, the registration officer must also inform the individual that there was a hearing on such and such a date. You were informed by service by the registration officer. You did not attend, but there was evidence laid in your absence. And I'm notifying you that we believe that evidence and we will take your name off the register for that constituency. The law provides that when you get that notice served on you again, when you get that notice served on you again, you have 7 days where you can appeal to a judge at the court. So you think that they just come off and you can't do nothing. You just can't do nothing. The law provides for you, Section 52 if I'm not mistaken, that you can appeal to a judge in chambers, in the court, to review your case. So it works both ways. If the registration officer decides, by me taking him off, whether you live there or not, the objector can appeal to the court. If you have a valid claim and your name come off, you can appeal to the judge too, in the same way. So there is protection in the legislation. Section 52, appeal. Appeal shall lie to a judge of the High Court, sitting in chambers, from any decision of a registration officer on any claim or objection which has been considered by him or her under this Act. Provided, however, that no appeal shall lie where claimant or objector has not availed himself or herself of his or her opportunity as provided by this Act of being heard by the registration officer on the claim or objection. So you don't turn up to the hearing. You don't do anything, but you're an appeal. Of course, if you have not been properly served notice, you do have a case, and a judge will hear you. And it can go on. But there is a regime. All we are doing today, Mr. Speaker, is to begin a process of strengthening this process that's there. It will be happening over the next few weeks, months, and years as we go forward. And we start early. Not in the last shower rain before the election, a day before election day and those type of things. We're giving everybody time to understand what the process is, to make representation, to call in, to meet your representative and question it. So we start now. And there are other things too that we hope that people who have a feeling this ain't right, that talk up about it, because we have to move forward in terms of fixing our system, that everyone could feel confident that we do the right thing. Mr. Speaker, before I sit down, I just want to make one last comment, and that has to do with the concept of boundary changes. Because the concept, the idea of boundaries is part of our whole electoral process too. And this for the last 10 years, 11 years, has been a sore point for many Kittichans. We understand that there are constituencies that are just too large compared to others. And boundaries in our Constitution and law is somewhat different from the electoral system. In the boundaries discussion and work, we speak about inhabitants. We talk only about people who live in a particular area. So that to fix a boundary is about where you reside. We look at the number of people in this constituency as opposed to the number of people in another constituency. That includes children who can't vote. Those under 18 are counted as well. So across the board, a constituency should be near equal. That's what the Constitution says in Schedule 2 to the Constitution. There are a set of rules that indicate how boundaries should be delimited, is the word they use, but divided. Rules for delimitation of constituencies, Schedule 2, and this comes from Section 50 of the Constitution. All constituencies shall contain as nearly equal numbers of inhabitants as appears to the Constituency Boundaries Commission to be reasonably practicable, but the Commission may depart from this rule to such extent as it considers expedient to take account of the following factors. That is to say, Rule 1 of the first part of that speaks to the fact that if there is to be an increase in the number of seats currently delimited, 18 St. Kitts and 3 in Nevis, that any new arrangement must guarantee that Nevis has 1/3 of the number of seats. So that if you want to put one more seat in St. Kitts, that's 9. Nevis only have 3. Nevis only have a quarter, not a third. So before you could give 1 in St. Kitts, you must increase in Nevis. 4 in Nevis and 9 in St. Kitts is still less than 1/4, than 1/3. Oh, more than 1/3. That is less. Okay? Leave that part. So, it was an important point in terms of the numbers. We also speak about the need to ensure adequate representation of sparsely populated rural areas, means of communicating geographic features like hills and guts and so on, and existing boundaries, parishes, and so forth. I raise that, Mr. Speaker, to state in this Honorable House that the Governor General has appointed a Boundaries Commission in which, in his own deliberate judgment, or on advice from the Prime Minister, having consulted the Leader of the Opposition, he has appointed licensed land surveyor, Mr. James Buchanan, to be chairman of the Boundaries Commission. The Honorable Prime Minister has appointed the Honorable Sean Richards, member for number 5, and member for number 3, the Honorable Akila Byron Nisbet, from the government benches. And the Leader of the Opposition has advised the Governor General to appoint himself and the Honorable Jeffrey Nisbet, Dr. Jeffrey Hanley, sorry, my apologies, member for Constituency number 1, to be on the commission. The commission has met. The commission has met and has had 2 meetings to date, but it is working. It has begun working. And we hope to, in this term, to fix this boundary debacle properly. we have serious problems. In constituency number 8, Keyon St. Peters, the inhabitants are approximately 7,400 people. 7,400. Constituency number 5, Sandy Point, Victory, is about 2,600. We have that type of anomaly as well in St. John's in Nevis and other constituencies, St. Paul's or St. George would be a good example. So there is a need for us to do that type of reform. And although it's about the Boundaries Commission, it is rightly considered to be part of an electoral reform process. This administration would hope that over the next months that there will be a proper delineation of the boundaries so that very early, long before we get close to the next election, without any urgency, no mad rush, doing it properly in terms of proper consultation, proper data, and all the other things that should make us be proud to know that our democracy is live and well, that would happen. Mr. Speaker, I want to take my seat, but I want to commend this bill to this Honorable House. It's a short bill, simple bill, but, Mr. Speaker, I was a little taken aback by the presentation made earlier, but I hope I have explained some of them, that people must register to vote where they live, where they reside. And with that, Mr. Speaker, those few words, I commend the bill. May it please you, Mr. Speaker.
Thank you, Honorable Attorney General. Any other presentations?
Mr. Speaker, so I rise.
You saw Jeffrey get
No, we're not going to be playing this game. Want to speak, you must indicate early and clearly. Can't wait till
Order. Honorable members, this is something that is carrying over from last session. So it has happened now. So let me now make it clear. Let me lay down the ground rules or rule with respect to speaking. The Honorable Attorney General finished up his presentation. There was a definite pause for any member to rise and speak. The mover of the bill rose to speak. He waited. At this point in time, I am going to, this time and this time only, use my discretion, and I'm going to allow the member opposite to speak. Going forward, honorable members, expect something different. Honorable members, I have just made a ruling. There's no need for any insisting that something happened and which did not happen. Member opposite.
Thank you very much, Mr. Speaker. I rise to make my brief contribution in this honorable House on the bill before us. Mr. Speaker, just to clear up things, the honorable member from number 5 asked me if I was making a presentation. I indicated to him that I'm just finishing up a note. So it's not that I wasn't going to speak, and I think the Honorable Prime Minister saw me when I went down, but let's move on, Mr. Speaker. I would wish at this time, Mr. Speaker, to make my contribution And in so doing, let me congratulate our senator for an excellent presentation this morning. I would not be as lengthy as her, Mr. Speaker. Mr. Speaker, a bill of this nature is of paramount importance to the citizens of St. Kitts and Nevis. And like my senator, ought not to be rushed. Mr. Speaker, I echo the question as the AG would have asked, as he indicated he heard, what's the rush to pass this bill, Mr. Speaker? Mr. Speaker, it is clear that the government has the numbers to effect any change that they wish. But it is important, Mr. Speaker, that the government also prioritize what they are bringing to the National Assembly. I am certain, Mr. Speaker, that there are more pressing issues the citizen would want to hear at this time. Many would have been highlighted by our senators, so I would not speak much about them. But, Mr. Speaker, the government is proposing to amend the Constitution. They came here today to do that. Yes, a first reading had been done. But, Mr. Speaker, making changes to our Constitution is not a day-to-day thing. It is of highest importance. And although this particular exercise does not require a referendum, you would expect that with their flooding of their airways daily with their propaganda, that they would have encouraged public discussion and input on a matter as important as this. Where is the transparency, Mr. Speaker? This cannot be democratic, Mr. Speaker.
Mr. Speaker, I raise a point of order. I waited to hear how the member for number 1 would explain how we are changing the Constitution today. And it's very clear, Mr. Speaker, that the Constitution is not being changed. I was at pains to point out that Section 29 of the Constitution speaks to all Commonwealth citizens can qualify to register to vote. And the bill today only determines a distinction between Caribbean Commonwealth citizens and other Commonwealth. He's not talking about this bill today. But
What is wrong with that?
well, I know, but it is misleading. It was misleading. It was misleading. But as I waited,
Mr. Speaker, during my presentation, certain phrases and questions would be posed based on what would have been discussed during the debate and also some of the bills that were laid before this honorable House trying to marry them together. But, Mr. Speaker, we move on. As I indicated, there might have been more pressing issues. I asked the question, where is the Freedom of Information Act and the Integrity in Public Life Act? And by true form, Mr. Speaker, in their ways, of no disclosure. Remember, up to now, Mr. Speaker, persons who are voting, persons who will be a part of this bill, eventually, they are asking about the IMF report. Mr. Speaker, I say we must do things and we must do it correctly. Because in 2008, if my memory serves me right, the former Labour government did put a committee in place that was broadband or broad-based, Mr. Speaker, when they were trying to make similar changes. And consultations were held not only with our citizens in St. Kitts and Nevis, but across the diaspora. And a report, Mr. Speaker, was also produced. Mr. Speaker, the question still stands. What is the rush for this bill when, Mr. Speaker, even the restaurant operators at Frigate Bay who are voters, who will be registered, didn't even have a chance to hear anything, not only about the bill, but even about the marina and sea revetment project that is happening presently, Mr. Speaker. I don't know if you have seen the environmental impact assessment for this project, Mr. Speaker. And I guess this is another old road or another cruise fiasco. With no consultation, we continue to do things that we know are in fact wrong, Mr. Speaker. And many of the constituents, they would have called me, and as a teacher, I will give those chatters the opportunity to say what they have to say, but I will continue my presentation, Mr. Speaker. As I was saying, Mr. Speaker, many of them, especially in the area, would have called me regarding what will happen to them should this bill be passed. And some of them, Mr. Speaker, are just a few months probably waiting, and even maybe a few days, Mr. Speaker. As the parliamentary representative for Frigate Bay and the entire East Bastille, it is my interest to keep up with what's happening in my constituency. And Mr. Speaker, any development to make my constituency better, I welcome it. Any bill that will put our country forward, I welcome it, but Mr. Speaker, it must be done correctly. Mr. Speaker, there are right ways of doing things and wrong. And a project of this magnitude has the potential to do enormous environmental and social damage, Mr. Speaker. The country needs information and needs to be convinced that the public interest is not being compromised, Mr. Speaker. Mr. Speaker, while having lunch the other day over there, it was discovered or shared by one of the workers that even the project that they're doing now, after the drawing, they discovered that something went wrong and they had to pause on the same project.
Mr. Speaker, I raise on a point of order, please. Mr. Speaker, I know that on the order paper there was a first reading for the National Conservation and Environmental Management Bill. And certainly that's not the bill that we are debating. But we are debating, Mr. Speaker, the National Assembly Elections Amendment Bill. However, what I'm hearing coming from the member for number 1, Mr. Speaker, is to do with a project over at Frigate Bay, in which Mr. Speaker has absolutely nothing to do with the bill that is currently being debated. The standing rules and orders, Mr. Speaker, speaks to relevance. And so when you're speaking on a particular bill, Mr. Speaker, you need to speak to the bill and not to some other matter which has absolutely nothing to do with it. What EIA and all of this has to do with how many months or years one must live in the Federation in order to qualify to vote, Mr. Speaker? Absolutely nothing. The member for number 1, Mr. Speaker, he needs to stick to the particulars of the bill as outlined in the standing rules and orders for this National Assembly.
Mr.
Thank
Speaker.
you, Honourable Member. I need to respond to the point of order. And the member for number 5 is absolutely correct. Like I indicated earlier to Senator Opposite, I would have said that I do allow some irrelevance at times, but persistence in irrelevance would, and the objection being raised by a member would call upon me to intervene. And I know it's your maiden presentation with respect to responding to a bill, but Standing Order 49.1, I'll read it for your guidance, states that the Speaker or the chairperson, after having called the attention of the National Assembly or committee to the conduct of a member who persists in irrelevance or tedious repetition either of his or her own arguments or of the arguments used by other members in debate, may direct him or her to discontinue his or her speech and to resume his or her seat. Of course, I would not do that. So I just want to indicate to you that you need to stick to the bill that's being debated, and if indeed you would want to interject other points, I would suggest you try to be as brief as possible with respect to, things that are not specific to the bill, for if not, you're under danger of the risk of being pointed out the relevance of your presentation. Continue, please.
Mr. Speaker, thank you very much. And it is a learning process, but I was trying to make certain references, Mr. Speaker, that not because we are having, or the government would have great numbers, that they will not be following rules, Mr. Speaker. But, Mr. Speaker, the definition in the bill itself should not seek to exclude any country within the Caribbean by the mere mention of countries having been cited in the bill. But it should instead read, any country located in the Caribbean as specified in Part 1 of the first schedule. Mr. Speaker, many persons would have expressed to me that the residency qualification of 1 year is too short. It is felt, Mr. Speaker, that persons need to get properly adopted and integrated into our society and our country before he or she is really given the right to vote. He or she, Mr. Speaker, I believe, must pay their dues before they achieve that. And Mr. Speaker, sometime we'll come back in here to discuss the constitutional amendment as it speaks specifically to the citizenship, moving from 14 to 7. So why not, Mr. Speaker, for us to allow everyone to be 3 years, Mr. Speaker? We know in the past, Mr. Speaker, doors like this that would have been opened would have created shenanigans, and we cannot afford, Mr. Speaker, to leave those doors open. But, Mr. Speaker, we must. That's what I said. Okay, shenanigans. That's. But, Mr. Speaker, we need to do it right. And, Mr. Speaker, we need to do real electoral reform as the country has been asking for. Mr. Speaker, there should be no discrimination between Caribbean and non-Caribbean Commonwealth citizens. In the modern world, Mr. Speaker, we are all one people. There must also be a level playing field, Mr. Speaker. All our residents here and all should face the same criteria of qualification to be registered and to vote. It is, in my view, a discrimination against non-Commonwealth citizens which ought to be ended rather than perpetuated. And truth be told, Mr. Speaker, we are supposed to have a bigger and a more inclusive, open mind and outlook in terms of these matters than just Commonwealth citizen, Mr. Speaker. Mr. Speaker, we have many people in our country from a number of non-Commonwealth countries who have been here for some time and others who will come to cast their lot with us. We must embrace them as well in voting after a suitable period of qualifications. And I stress, Mr. Speaker, it should be a leveled playing field. With that said, Mr. Speaker, I suggest that the period of qualification be standard for all non-citizens. If we are saying 3 years, 3 years. If we are saying 1 year, 1 year. And if you want to come back and take it to 5 as persons would be getting their citizenship in 7 years, let it be 5 years and they'll have an idea of what our electoral process is all about, Mr. Speaker. Yes. Mr. Speaker, we are in a crisis in managing the economy stemming from the effects of COVID, and the Honorable AG spoke about, made mention of the COVID like others, Mr. Speaker. We are in a crisis aiding our workers and providing adequate relief and support to them in light of loss of jobs, business closure, and loss in the quality of living for our people, Mr. Speaker. And these amendments, Mr. Speaker, are we saying that they are the best that can be done given the times that we are living in, Mr. Speaker? Mr. Speaker, I don't think that now is the time to try and play politics. If we are doing electoral reform, let us do it properly, Mr. Speaker. And the government focus must be on our people. But Mr. Speaker, if we look at that, we might be thinking differently based on what persons are experiencing and expressing. Voters we are talking about. Mr. Speaker, as a Lions Club member, our code of ethics speaks to building up and not destroy. And I try my best to carry out this, Mr. Speaker. But, Mr. Speaker, we are failing our teachers and students. Imagine, Mr. Speaker, the government is here today, this afternoon, fighting to give voting rights to non-Commonwealth citizens, and students cannot have access to their lessons online because they have... You saying something? They have no... because they have no means to do so via the tablets or the computers or even internet access at home. Like my senator, wouldn't it have been better for us to be here fighting for our children to be able to continue their schooling through access to technology, Mr. Speaker? What are we doing to help those parents who are crying out for data for devices that the children are using?
Mr. Speaker, I raise on a point of order. I might not be a teacher, and I'm not a doctor. But as the Minister of Education, I would like to point out that some 1,200 devices have just recently been allocated to students across this federation, not just in St. Kitts, but in Nevis as well.
5,000 students.
In addition to that, Mr. Speaker,
5,000.
those devices were allocated on the basis of need, as indicated by the students and parents themselves. I go further, Mr. Speaker, to indicate that over 200 households in this country, as a result of the efforts of this government and the Ministry of Education, were able to receive internet connectivity at home, paid for by this government. So it is inaccurate for the member opposite to make a statement such as he so did just now. Thank you, Mr. Speaker.
Mr. Speaker, nowhere in my presentation I did not say that devices were not given out. They are not adequate, Honorable Member for 7. I visit schools all the time. They are not adequate, Mr. Speaker, but I will move on, Mr. Speaker. But Mr. Speaker, I interject because I did house to house yesterday afternoon in the Ponce Pasture area in my constituency. As I promised, every quarter I will be around, but I've been around on a daily basis, but strategically. And Mr. Speaker, while doing house to house, it was very heartbreaking to hear the cry of some of the parents of those students who are attending the Tucker Clark Primary School. Because as my good constituent got up and he spoke about the devices, I would hope after, Mr. Speaker, he will speak about the poor conditions of our bathrooms that our students and even teachers who sometimes leave the school premises to go elsewhere to use. You can only imagine what the children are dealing with, Mr. Speaker. And these are some of the things I mentioned that should be priority. Labs are being renovated right now, Mr. Speaker, with no intention of completion before December. It means that students would not have that contact time and engagement in those specific labs, Mr. Speaker. Let us outfit our classrooms with adequate equipment that we need at this time, Mr. Speaker. The Honorable Member for 7, in his earlier presentation, reminded the country about the importance of hand sanitizing and all of those which I fully support, Mr. Speaker. But the reality is, and the Minister of Education is quite aware of the realities. And I understand his pain at times. But Mr. Speaker, our schools even right now are not adequately outfitted with even the dispensers that are required to be used.
Honourable Member, I'm really resisting intervening, but I remind you that you need to be relevant.
Okay, Mr. Speaker, I move
maybe I've tried to. I think I've tried to say that there's nothing wrong with mentioning things that are, extraneous to the bill, but you should attempt at all times to make it relevant, try to tie it to the bill instead of going on and on about something that definitely does not relate to the bill.
But I made that interjection because of the Honorable Minister for Education having the point of order to give him something else to go and check or pay attention to, Mr. Speaker. He knows that I'm very passionate about education, and no doubt he supported me as well. Mr. Speaker, I am not trying to criticize in any way, Mr. Speaker, but also just highlighting some shortcomings. And as we go along, Mr. Speaker, I can assure you that we will be getting it very right, Mr. Speaker. But, Mr. Speaker, I move along and I say, Mr. Speaker, a bill of this sort, I really would have liked to hear what our young parliamentarians would have had to say about it and share their views, Mr. Speaker. Because in the past, and the Honorable Sonia Body Thompson and Honorable Akila will attest to that, where many times bills of these importance would have been shared with our youth and our young parliamentarians, and they bring back information because consultation, Mr. Speaker, is of paramount importance. Mr. Speaker, in number 4 amendment section 37(3), where a person who is ordinary resident in St. Christopher and Nevis is registered as a voter for the constituency and he or she has ceased to reside in that constituency, then he or she shall, and we went through A and B. But Mr. Speaker, I am not certain, and again I am new, and I am always willing to learn. But I don't know if I missed it, but the mover of the bill did not explain the process as how this would be done. This, in my view, Mr. Speaker, should be spelled out in the act and not left for someone to be wondering. The mover of the bill, Mr. Speaker, from number 7, was chanting while the Honorable AG was making his presentation specifically about persons moving from one place or voting. But Mr. Speaker, if we should, or if I can ask the Honorable Member 7 to roll back the curtains of memory, I am certain, Mr. Speaker, he would be smiling, knowing many of what he is talking about today. He was, in fact, a part of it for 18 years and probably the great engineer to it, Mr. Speaker, before he was fired. So, Mr. Speaker, it's only when it suits us, it appears though we make certain reaction. How transparent and fair the process would be, Mr. Speaker. The AG was talking about certain things, Mr. Speaker, but the very existing objection process has caused several challenges, Mr. Speaker. And I ask, would they just be trying to remove persons, names from the list, Mr. Speaker? That is what has been happening all along, Mr. Speaker. Listening to the AG sounded very good because you were the mastermind behind it, as I said, Honorable Member for 7. And now want to paint this glorious picture. But the realities are the realities, Mr. Speaker, because the AG knows that that is not the reality. Mr. Speaker, as the AG mentioned about one of the process in the objection or the one of the functions of the registration officer. Mr. Speaker, since the general elections on June 5th, and Honorable AG, you can probably find out as well, as indicated that monthly registered voters, the list ought to be posted as the law requires. Mr. Speaker, not one list has been posted in constituency number 1 since our last general elections. And Mr.
Speaker,
yes.
I rise on a point of order. Mr. Speaker, that's not the information that has been presented to the ministry. What we do know, and this is not something that's just started, that for some time now, there are people who go out and pull down the lists when they're posted, and the lists are defaced. There are people who interfere with it, and it's clearly something that, if discovered, the police will have to deal with it. So to say that that is not so, what I did say, and we do know happens, is that agents from the different parties do attend to the office of the supervisor of election and collect the list over the counter.
Thank you very much, Honorable AG. But again, Mr. Speaker, that is not the realities. And I will give him a homework assignment, and I will ask him to ask over in the electoral office how many times I would have visited that office after the date when the voters list had to be posted, and even show them photos of the area that they're supposed to be blank, and your camera has the timing. Mr. Speaker, nobody going around in this kind of time to be just pulling down voters list. But we move on, Mr. Speaker. And Mr. Speaker, I believe the time has come for us to have...
I'm sorry, Mr. Speaker,
yes,
if I may, just one more point. What I would say, Mr. Speaker, that there is now a process in place, that it cannot be free and nothing, that the lists are now published online. So they also can be had by the general public. And there are different websites. You can go, SKNIS, the Ministry of Justice and Legal Affairs now has its own website, where the lists are published monthly.
Thank you very much for the information.
Mike.
Sorry. Thank you very much, Honorable AG, for the information. I will start to do my checks to make sure that they are current as well. But Mr. Speaker, the AG, the Attorney General, Honorable Byron, while he made his presentation, I noted something and I share it. In his argument, Mr. Speaker, it appeared to me that he was seeking to justify the distinction between CARICOM and non-CARICOM Commonwealth citizen. I don't think, Mr. Speaker, that that was very wise, and I think it's unfair because it is discrimination, Mr. Speaker, against the latter. Mr. Speaker, a person from Fiji, example, living here for 3 years or more can be just as responsible, productive, and law-abiding as somebody from Dominica or some other part. And Haiti, as my senator just said. Mr. Speaker, aren't we supposed to be a modern country is the question I will ask. And as I get ready to wrap up, Mr. Speaker, please allow me to find out from the members opposite, as I am new to the process. But with this proposed bill that is before us, what if, God forbid, another pandemic, and COVID, from what they're saying, will not be leaving us anytime soon, but thank God we have been doing our best. But what if, for some reason, another pandemic like this occurs, and some of our citizens are trapped overseas for more than the 6 months? And I even take it further because medical purposes and treatments, persons are traveling. Yeah, but you see, Mr. Speaker, when you are explaining something, you need to be explaining it, not talking in about Mr. Speaker.
It says that they moved for next constituency. They haven't moved.
Go ahead.
Mr. Speaker, I would want to find out where would those persons exist.
Constituency hospital overseas.
And I hope you'll be the matron. As I wrap up my presentation, Mr. Speaker, I find it difficult to comprehend the urgency of this bill. I am opposed to any amendments to the electoral laws without wide consultations and debate, Mr. Speaker. There needs to be comprehensive electoral reform, not merely tweaks at the whim and fancy of the Prime Minister, who leads a party with the least number of votes in the country. And of course, as he would have said that he know me well, so do I, Mr. Speaker. It is simple for me, Mr. Speaker. Comprehensive electoral reform for the people to decide on their options. And electoral reform, Mr. Speaker, is really the only option at this time, Mr. Speaker. Mr. Speaker, the government must stop forcing important decisions down the throats of people just because they won. Your mandate on important constitutional matters is what you promise, not what you sit in a back room and decide. Who gets to vote in this country should not be at the whim and fancy of the people who benefit from those votes. It should be decided, Mr. Speaker, by the people. Voting is a constitutional matter, and modern countries decide on constitutional matters, Mr. Speaker, by way of referendums and not just winning elections, Mr. Speaker. Mr. Speaker, I am willing to volunteer on the Electoral Reform Commission. I am willing to participate in public virtual meetings to hear from all people of this country. I am ready to submit comprehensive electoral and constitutional reforms to the people and give them the choice. That is how you modernize a country, Mr. Speaker. This today, the bill is a continuation, I would say, of the normal arrogance and incompetent government who only give lip service to real reform, Mr. Speaker. May it please you, Mr. Speaker.
Thank you very much, the Honorable Jeffrey Hanley, member for St. Christopher. St. Christopher 1.
What's that? Yes? You're not speaking.
I recognize the Honorable member for St. Christopher 6, Dr. Denzel Douglas.
Mistakes made on my side. I shall be thorough. Mr. Speaker. The mic needs to be turned on. Right. Yeah, Mr. Speaker, I want to thank you for giving me leave to make my own contribution on this very important bill, the National Assembly Elections Act, which the government of today considers to be so timely and important that it must be brought here before other critical and important matters that the people of this country wish to know about. And before I get into the meat of my short presentation, I I really want to emphasize the point that has been made by the two speakers on this side of the House. Firstly, the Honorable Senator Dr. Clark, and secondly, well supported by the elected representative for constituency number 1, Dr. Hanley. And the point I think that they were trying to make and have made very, very clearly, and which I now also emphasize, is that there are critical matters of state which they believe should have been part of the legislative agenda, especially at this time. And reference was being made, for example, to the inadequacy, the inadequate preparation of our schools post-COVID-19 reopening, and also other critical matters pertaining to the hundreds of unemployed people who have lost their jobs, who are asking every day where they are going to get the next meal from. This is what they were saying this morning and this afternoon, yet there was ridicule on the other side because they bring to this House the attention that has been brought to them from their constituents and from people of goodwill who are asking them to speak on these critical issues while we are debating this important bill, the National Assembly Elections Amendment Bill 2020. So I don't understand why there's this scoffing and laughing at these presenters on this side. Jeffrey Hanley just won his seat. In fact, it's twice he win it. Twice. And he has the right to speak for people in his constituency who have come to him and are expressing the concerns that they're finding in living decently and well here in St. Kitts and Nevis. So what is wrong with that? And so, Mr. Speaker, I had to get that out of the way because as I sat here, I said it is unfair. They are not extraneous. They are not saying things which are irrelevant. These are relevant in terms of the point of timeliness of this bill. Why is it that this bill is so important that it comes before other matters that are affecting people's lives? That's what they're asking. And so, Mr. Speaker, I know that my colleagues here do not wish to be disrespectful to you or to anyone else, but for God's sake, let them speak. They're all educated people, they know what they're doing. Don't laugh at them and try to ridicule them because they're making certain points. And so, Mr. Speaker, I now turn to the meat of the matter. Because you see, Mr. Speaker, this bill really has a history. And the Attorney General, being learned, I expect, gave us a brief history of maybe why we are here. And he took us back to 1952, when people ordinary did not have the right to vote. And then there was adult suffrage, and people ordinary had the right to vote. And over the years, all around the world, whether it is the British territories, French, Dutch, African, or wherever, in the Pacific, wherever, they moved forward in granting more legislative rights to people for them to be able to vote. And so in independence in 1983, the law which was then in place was changed. And one of the changes that the new constitutional changes brought was allowing people who would normally be resident where they were, but who might have traveled abroad and moved to some other place of residence. The law gave them the right to choose where to register to vote. That is the law. And to a large extent, the law also provided people who were of Commonwealth origin, even though they are not born here in St. Kitts and Nevis, but in other Commonwealth countries, it gave them the right to vote if they were resident for at least 12 months. So, two things. One, there was the right to vote even if you moved and went somewhere else, but you were resident there and resident here. You had that right to determine where you are really resident, especially given the law that it is that person who will decide based on his intention possibly to return. That is the law. That is the present effective law. And no. There's no stretch there. That is the law. And secondly, Mr. Speaker, it also made it possible for Commonwealth people, no matter where in the Commonwealth they were from, as he said, whether they were in far-flung countries, and I don't know which country today is so far-flung that St. Kitts and Nevis is not known to it. We are a global country. As simple and small as we are global. And so, whether you live in Tonga or Fiji or wherever, that does not mean that you don't know where St. Kitts and Nevis is. That does not mean that we do not have diplomatic relationship established. That does not mean that our students being given Commonwealth scholarships are not given the opportunity to go to those countries, or those come to this country, St. Kitts and Nevis. So the point about far-flung countries with no attachment here is a non-point with respect, because that no longer operates in a globalized world. And we are part of that global international community. So, Mr. Speaker, Czechoslovakia is not a Commonwealth country. The time is going to come where if you have a Czechoslovakian also resident in St. Kitts, also an economic citizen in St. Kitts and Nevis, as they are saying that they are going to do, they will be allowed to vote. And that is why I think that today we should be thinking globally. And that is the point that Dr. Clark was making this morning. That is the point that the member for number 1 has been making this afternoon. Let us be global in our approach in terms of, not everybody. There must be qualifying indices to be met. And once they are met, then we should make sure that it is okay. I'm going to come to that, this global point. But the point that I think that we need to emphasize here, which are the concerns of this bill in particular, is that historically, we have moved from being a closed-in country to one that is global and expansive. One that is asking people from around the world to come in here as investors, to provide jobs for our people, to ensure that our people can benefit in numerous ways by their interaction, their presence here with us. And whether it is a Commonwealth, Caribbean country, or whether we are speaking of non-Caribbean Commonwealth countries, Canada, the United Kingdom, Nigeria, India, whether we are speaking of these, what my colleagues have said all morning and this afternoon is that what is the reason for you to lock them out from being able to register to vote, when in fact presently they have that right to vote? That is what they are questioning, and they have a right to question that. Because that is not the way we are saying that our country needs to move at this particular time. So we are saying, what is the reason? What is the rush so that it is so high up on the legislative agenda, so that today it is being rushed into law to be effective and closing out people? And they made reference to the Indians who are down in Port Zante, those who are working in the Port Zante shops, and who presently have the right to vote because they are registered. And there are those as well who presently meet the requirements of being registered to vote because they have been here for more than 12 months or 12 months. But this law is now saying, you have missed the boat, because if you have not registered, when this is being passed today, even though you are here for 12 months, you can't get registered again until 3 years. That is what they are saying is the problem. And that is what they are saying, and I support their views. That is what they are questioning. Why are you not making some kind of effort to include them? Give 6 months before application and say to those who are Commonwealth non-Caribbean, if you have been here for 12 months and less than 3 years or whatever time, please, for the next 6 months, go and get registered, because in 6 months' time, you won't be able to register until after 3 years. That's what they are saying. Yes, I will support it that way, because I think it's the right thing to do. It's the right thing to do. You can't exclude people who presently qualify. Give them time, and the age knows that is the right thing to do. You need to have a grandfather clause. You know that, and you can do it. But it is being deliberate, because I believe they are getting at the Nigerian students and the Indians down there in Port Zante. That is what I believe. That is what I believe. To exclude them from being able to register to vote because they don't like maybe how they voted in the last elections. That's the point. Everybody knows that. The whole of St. Kitts knows that. St. Kitts and Nevis. Well, I don't know, you know. I ain't sure under you if it is so. I ain't sure. It was secret under me, but me ain't sure anymore. After what happened in the last election there in June, me ain't sure anymore. That is the point I am making. You think that this is a joke, AG? This is no joke. This is serious business we are discussing. And so, Mr. Speaker, they have the right to raise the matters that they have raised. And I want to commend Dr. Clark and also Dr. Hanley, member for number 1, for the way that they have brought this debate to life. I want to thank them for the breadth of the analyses that they have made. I want to thank them for the quality of their presentation as well. Had all of them spellbound this morning. I want to thank Dr. Clark for that. She is definitely a gem in this parliament. And so, Mr. Speaker, the point must be made that even if you want to do something, which is, I believe, bring the people from the Dominican Republic and our Guyanese and Jamaican friends who are here, bring them quickly into a position where they can vote, especially from Haiti and the Dominican Republic. You don't have to give them that right to register by excluding anyone else. Let all of them remain and bring in those who you want to come in at the same time. Because you're right, Haiti is a member of the CARICOM. They are a member of the CARICOM, but they're not allowed to register to vote here. You understand? And we are saying that the people of the Dominican Republic, who you now want to be able to register to vote, even though you have found creative ways which are illegal to get them registered, let them now be registered. We ain't gonna make no noise about that. But don't exclude the Indians and the Canadians and the British and the people from Africa and so forth. That is the point we want to make today.
Mr. Speaker, on a point of order.
That is the point I want to make.
Mr. Speaker, on a point of order, the member for number 6 is deliberately misrepresenting the bill. The bill before this House does not exclude no Canadian, no Indian. The bill explicitly provides for their ability to be registered to vote. What the bill does is that it sets out the residency criteria that pertains to them. No Indian, no Canadian, in fact, no one who is currently part of the Commonwealth country grouping listed in the law or on the register is excluded. The member for number 6 is misleading and it's been untruthful in that representation, Mr. Speaker. So there is no need for that kind of representation to be made. There is no exclusion of any Commonwealth citizen. This law strengthens their ability. No exclusion, none whatsoever.
I really don't think, I don't think that the member for number 7 is serious about what he just said.
I just said.
If a Commonwealth person, an Indian down at Port Zante, has been here for 12 months and he has not registered, you are now saying to him, although he was legally resident here in this country and could have voted, could have registered to vote under the present existing law, you're now saying after this law is passed in this parliament today, he can't register until after 3 years. And we're saying that that is discriminatory and it is wrong. That is what we are saying. And you're saying that you broaden it. Broaden what? You've narrowed it. That is what you've done. And it is deliberate because I believe you have some ulterior motive for doing this. I take that back. Okay? I'm taking it back. So I believe, Mr. Speaker, these are the critical points that were being argued this morning by the members on this side. And again, I repeat, if it is that the government wants to make it easier for the Dominican Republic people to get registered to vote, and those from Haiti, because even though we're talking about CARICOM countries, Haiti and the Caribbean countries, Haiti and the Dominican Republic people are not allowed to vote, unless they would have qualified otherwise. Yes. And we are saying, if the intention of this government is to make a law that brings them closer to being registered to vote, we would want to see that law before us rather than a law that excludes the Commonwealth persons who are not citizens of the Caribbean region. That is what I'm saying. You could say what you feel like, but that is what it is by facts. And by law now you're making it so. So, Mr. Speaker, I want to move on. So that is the critical point, I believe, that has been made by my colleagues. And secondly, we are saying there is concern about how this 6 months being allowed to remain for 6 months there after you would have been told you no longer qualify to be registered there and your name removed from the register, and you are supposed to be registering somewhere else, how is that going to be implemented? What's the process? What's the mechanism? And so we are saying, Mr. Speaker, that is fraught with inconsistencies, difficulties, and may even be illegal, because there's no reason for anyone who can vote now and is registered to have his name removed. And then 6 months after he's been told, you're now registered over there. That is what this law is saying. Look at it, 37(3). Look at paragraph 2 of this bill. Sorry, not paragraph, to paragraph 4. Section 4, amendment of section 37.
You mean clause 4 in the paragraph?
It is also a paragraph or section. Section or paragraph is the same. Don't tell me, I know what it is. Whether it is clause 4, section 4, paragraph 4 of this piece of legislation that we are dealing with, which amends section 37. If you go down to section 37, subsection 3, say where a person who is ordinary resident in St. Christopher and Nevis is registered as a voter for a constituency, and he or she has ceased to reside in that constituency, then he or she continue to be registered as a voter for that constituency, but, I put in my but for a period not exceeding 6 months, and register in the other constituency that he or she is qualified to be registered in as a voter. And so the question is asked, again by me, as was asked before, how do we really determine these things? Is it as easy as it is being put here on paper? And we said no. And Dr. Clark made reference to the multiple relationship individual or the multiple resident individual. Say, Mama, why? You understand? How do you determine that he or she is saying that I am registered here? For the last 6 months, I have been over here. I am still with the intention of going back over there, where I have come from for the last 6 months. And you're going to tell me that because you have not seen him or her over there for 6 months, where he is registered, you now said to him, well, I notice you have not been resident here for 6 months, and you will have to now change your registration to another constituency where we believe you are living, you are residing with someone else. When the man or woman tells you, but you can't do that because I intend to go back there. And the law allows him that right at the moment. Isn't it so? Eh? No. Why isn't it so? No. Section what? Of the original bill? Let me see the original bill. I don't know why you're telling me no, because that is what it is. And we are saying that is fraught with difficulties. Fraught with difficulties and danger. Because you are depriving the person, if the election is being called within a specific period of time, you are preventing that person from being able to continue to register, to vote, where he is presently registered. And what Dr. Clark said is a reality. How many young men or young women decide today I am living here in Molyneux, but I want to continue to visit my girl and or my partner in some other constituency. But even though I am now here because I have a baby with this girl over here in a different constituency, and I make sure I want to spend some time with my young kid, you are saying that he's been removed from where he's registered, and he now have to go and register where he is visiting or spending time and residential for a time with his young child and mother. Come on, man. We need to make this clear. And that is what Dr. Clark has been saying, and Dr. Hanley. There has to be serious attempts to qualify these things. Who is going to police these things? Who is going to do that? You know why I really smell a rat here? Because look at what happened over the last 5 years. In constituency number 4 alone, close to 200 people were disqualified who were registered in number 4. They had their registration totally uprooted. No proper advice was given to them. Nothing about appeal, as the Attorney General was saying earlier today. A lot of them did not get any letter of their right to appeal. None of them, those who spoke to me, none of them had any letter that told them they can go and appeal. They did not even appear at the hearings because they were not duly informed. And he's trying to explain that, oh, they ain't get no letter because they're not living there. What nonsense is that? So you're going to take off a man's name because somebody who is a neighbor in another constituency sees him waking up there because he's looking after his young child? He has the right to do that. And this is the point, Mr. Speaker, that we are making here. We are making this point, saying clearly, if you are going to use the same practices that we have seen in the past, then this is fraught with danger and disenfranchisement of a lot of people. And so I don't believe the intention of this government is honorable. I don't think so. And so, Mr. Speaker,
Should people be able to register if they don't want to?
sorry. We want to be able we want to be able to see clear guidelines as to how this new policy, as a result of this new legislation, is going to be applied. We are in the dark, and we are members of Parliament. Yes, we are not sitting in the cabinet, so we are not privy to what the executive has decided. But we as parliamentarians who have to bring this piece of legislation into law, we need to know, we have the right to know clearly what is your intention in terms of how this is going to be applied, if it is going to be informing people in the future as to how they are going to be registered. Mr. Speaker, that brings me now to another important, very important matter. How does it treat those, and that was raised earlier, and she was scoffed at, and he was also. How does it treat the registered voters who are already overseas and registered, when this law is applied, they would have been non-resident, thus not resident in St. Kitts. They are presently registered in a particular constituency. How are they going to be affected? You know why I'm asking this question? Because again, I question the real motive of this government. You see, there have been several attempts by this government to disenfranchise the overseas voter. One attempt was even brought to this very parliament, and they didn't have the votes to effect it. And so, Mr. Speaker, the people overseas, as Jeffrey was saying earlier, he was receiving calls. Does this affect us who are overseas voters? Because we know that the government had a policy of discontinuing the rights that we have to vote in elections because we are overseas. Is this another veiled attempt on the part of the government to disenfranchise us as those who are non-Caribbean Commonwealth citizens are being given the disenfranchisement action, having been resident here for 12 months, but because they were not registered, now have to wait for 3 years to register? People are asking these questions, and they are very relevant questions. They are concerned. And as a parliamentarian, I am concerned myself. Mr. Speaker, I believe that the motive of the government is being questioned. It is being questioned, Mr. Speaker, because some of the basic principles that govern the right of a resident to register, those principles are being uprooted and violated.
Which principle? The principle that the government said anyway.
Mr. Speaker, again, as I said, it is discriminatory, and there should not be any practice of discrimination in a world that is becoming more globalized, especially as it applies to St. Kitts and Nevis, where we are inviting investors who have citizenship from all over the world to come here and invest with us.
So you give away your country to them?
Giving away what country?
So what?
Giving away what country? You have given away more of the country than anyone else.
There's nothing to do with investment.
And we are saying, Mr. Speaker, these are critical points that have to be considered.
We're going to buy votes.
And why is it there's a concern? Because those 198 or over 200 people who were disenfranchised in constituency number 4, they made a frantic effort to get their names back on the list. Only 2 of them were successful. 2 of them were successful. And it is only because of technicalities why the others were not given the right to have their names re-registered in the constituency that they were removed from. But that does not mean that the law and the court did not recognize that something sinister and wrong had taken place with regard to these people. Technicalities. That is why only 2 got their names back on. Maxine Stanley and Timothy Abbott, to be specific. The others have the right, legal right, but technicalities prevented them from being added. And that is what I'm saying. They removed their names so that people had to go to the court in the last 2 days before the election to get their names on. And that is what I am saying. I am saying that based on that practice by this administration in the last election, they will do anything, including pulling wools over people's eyes with regard to the overseas voters when this bill is applied against them. And so, Mr. Speaker, the matter of the overseas voter needs to be properly addressed. You can't disenfranchise people in this kind of legislation. No, it's going to lead to confusion here in this country. And so when his time comes to speak, he speaks. And so, Mr. Speaker, I want also, never was able to, I want to round off by making some closing remarks. Of course, on the bill. I have the skill to do that. Mr. Speaker, there is a way, we believe, that we can advance the integrity of the voting system, electoral system here in this our country. When many years ago in 2007, it became necessary for us to do that, we did it. No, we introduced, Mr. Speaker, just you're going to get a time to talk again next week or whenever, not today. Mr. Speaker, again, I say that it is critically important that we understand how we do things properly. Member for number 1, member for the senator on this side, spoke about the need for consultation. This is so critically important. Why no consultation has been done? We have the comments from the legal fraternity. We have the comments from the Bar Association. We have the comments from civil society on this matter. And we continue to say that we did it in a particular way in the past. We consulted at home and abroad to make sure that something like this, which is so fundamental, that it be done properly, in a way to include and not to exclude, in a way to respond to the global realities that St. Kitts and Nevis is facing today, to ensure that people would have had the right to give their input. Why no consultation? Remember for number 1. In closing, he said, I am prepared to be part of a commission or committee in order to review the electoral laws so that they can meet the specific criteria of excellence that we all want. Mr. Speaker, why not subject this to a referendum? People of all political persuasions want to deal with this, not in a political partisan way. They would want to do it by way of referendum. If you believe that you want to disenfranchise in terms of their registration, the Commonwealth persons who are not from the Caribbean, why not test it by us? Test it with us. That is what people are saying. Why not a referendum? Why rush it in this parliament today at this time? And so, Mr. Speaker, I must say, it's really a pity that we have reached to this stage. We speak of being a more inclusive society. We speak of breaking down the barriers the political tribalism that to some extent have separated us for many years. This is 2020. We would want to make sure that the government's attitude is one which is inclusive, one which is sensitive to the needs of the people, especially given this present environment of COVID-19 pandemic. Since I've been here, I've had no less than 2 WhatsApp messages from people asking, can't you say something about the fact that we have nothing to eat because we do not have any jobs, no salary, no wages? These are the messages that have been coming through on my cell phone. I have said to some of them, 2 of them, maybe we can go to the Ministry of Social Services, the Ministry of Dean Hamilton, Honorable Hamilton, the member for Constituency number 8. Maybe I can speak to him privately for you. These are the imperatives that our people are asking that we deal with today. Mr. Speaker, I want to close by saying we do not have to go this route. It could be better done. May God help us here. May it please you, Mr. Speaker.
Thank you very much. The Honorable Dr. Denzel Douglas, member for St. Christopher. Yes, the Right Honorable Dr. Denzel Douglas, member for St. Christopher 6. I recognize the Honorable Member for St. Christopher 5, Sean Richards.
Mr. Speaker, I rise to make a presentation on this, the National Assembly Elections Amendment Bill 2020. The truth is, Mr. Speaker, that initially I wasn't minded to make a presentation, but as I sat and as I listened, I think it is necessary, Mr. Speaker, for me to make some statements relative to this debate. I make them, Mr. Speaker, one, out of some particular experiences that I've had, but more so, Mr. Speaker, as a citizen of the Federation of St. Kitts and Nevis, and one who I think has some understanding relative to the right to vote. Mr. Speaker, I've been involved in elective politics since the year 2004. I seem to recall, Mr. Speaker, that at the end of every single election here in the Federation of St. Kitts and Nevis, we have had many controversial matters. Perhaps I should add that not only at the end of each election, but even throughout the process leading up to general elections here in the Federation. You have had many cases before the court, Mr. Speaker, relative to persons registering and voting in constituencies where they ought not to have registered. The Honorable Attorney General in his presentation would have made reference to one such matter which ended up before the court relative to Laureen James versus Dudley Williams. In my own constituency, Mr. Speaker, I've had to object to persons who should not have been able to register in St. Christopher 5, and also had a case which ended up before the court, Mr. Speaker. Mr. Speaker, outside of that, you have also had matters being taken before the court relative to constituency boundaries. As recently as the elections of 2020 and prior to the elections of 2015 and the elections of 2010. In all of those matters, I have been a party to those cases, Mr. Speaker. Even as we are here in this National Assembly, we still have the matter of 2015 before the court. That is a matter which would have gone, Mr. Speaker, to as far as the Privy Council. And maybe while I am on that particular point, Mr. Speaker, that it should be pointed out that one of the key things which came out of that particular court matter was that to do with the gazetting of those boundaries which an attempt had been made to change 1 month before a general election. And so there are 2 points there, Mr. Speaker, that I can speak to. In the first instance, we're hearing about a rush to make changes to the electoral laws. As far as I'm aware, Mr. Speaker, the last election was held on the 5th of June, 2020. Constitutionally, the next election, Mr. Speaker, is due sometime in 2025. We are in the month of October, July, August, September, October. Only 4 months after the last general election, and approximately some 4 years and 8 months before a next general election is due to be held in the Federation of St. Kitts and Nevis. So, Mr. Speaker, when persons refer to a rush, there is no rush because there is no election which is due at this particular point in time. Unlike 2015, whereby 1 month before the general elections had been held, there was a rush then, Mr. Speaker, to change the boundaries here in the Federation of St. Kitts and Nevis. Mr. Speaker, you can determine the difference for yourself when one speaks to a rush. Mr. Speaker, I mentioned gazetting. And one of the reasons, Mr. Speaker, why we would have been successful in 2015 is that the Privy Council agreed that that particular matter could not have been gazetted within the time stated. Because until it is gazetted, Mr. Speaker, it doesn't become law. The point I am making, Mr. Speaker, is that I'm hearing that there are some persons who today may have been here for a year as Commonwealth citizens, and thus they are able to be registered to vote. Mr. Speaker, it therefore means that until this particular piece of legislation is gazetted, that those individuals, they still can go, Mr. Speaker, and register to vote. As a matter of fact, Mr. Speaker, this particular piece of legislation came before the Parliament in September for a first reading. So that all of those opposite, Mr. Speaker, who are expressing a concern about be it constituents or other persons not being able to register, they should have read it then, Mr. Speaker, and informed those persons that the law is about to change, and as such, take advantage now of the opportunity to become registered voters. That is the simple point, Mr. Speaker. But instead, we're in this Parliament hearing something absolutely different from those who say they care about their constituents and constituents not being able to register to vote. Mr. Speaker, I can even take that point a little further. Because, Mr. Speaker, when a law comes into effect, sometimes we benefit on one hand or we lose on the other hand, Mr. Speaker. Mr. Speaker, prior to, I think it would have been last year, it was illegal to smoke marijuana, to grow marijuana here in the Federation of St. Kitts and Nevis. There are persons, Mr. Speaker, who would have suffered time in prison. There are persons, Mr. Speaker, who would have suffered from having a criminal record that prevented them from gaining certain things. There are persons, Mr. Speaker, who would have been fined because that was the law then. But when the law changes, Mr. Speaker, the law changes, and it means that going forward, this is what pertains. And therefore, that is the point, Mr. Speaker, that if you are able to register after living here for 1 year, that no longer pertains if you're outside of the Commonwealth, the CARICOM area, Mr. Speaker. It's as simple as that. Mr. Speaker, once ago, you park any place on the road. Today, the police paints a yellow line. And what is your argument? That for the last 5 years I was able to park here, and I should be able to continue to park here because I did it for the last 5 years? The law has changed. And so if the law has changed, Mr. Speaker, you abide and you adjust within the confines of the law. It is simple. Mr. Speaker, I was in here as a member of the opposition then, and a bill was brought to this parliament in terms of the age at which persons can sell alcohol, the age at which persons can consume alcohol. And so what does someone who was then 17 years and 9 months and had been accustomed to do it say? I've been accustomed to do it, and so the law has changed, and I should be able to continue to do so. The law doesn't work like that, Mr. Speaker. The law has changed, and so going forward, this is the new law, and this is what you are expected to abide by, Mr. Speaker. As simple as that. And it seems as though some persons on the opposite side simply cannot comprehend that simple fact, Mr. Speaker. Mr. Speaker, there was a time I lived outside of St. Kitts. There was a time, Mr. Speaker, I lived in St. Thomas. Shortly after graduating from high school, Mr. Speaker, I migrated there. And Mr. Speaker, I lived there for several years. Caribbean country, non-Commonwealth, yes, non-CARICOM. But I lived there, Mr. Speaker. I studied there. I worked there. I paid taxes there, Mr. Speaker. But never once, Mr. Speaker, during that particular point in time, had the right to become a registered voter in that territory. Because there is a criteria in place. And if you don't meet that particular criteria, Mr. Speaker, you can't register. I'm hearing persons saying that because you come here, you're paying taxes, you own a house, etc., that you should be able to participate and vote after 1 year. Mr. Speaker, it doesn't work like that in other places. And so you could live in the US, you could live in St. Thomas right here in the Caribbean for 5, 10, 15, 20 years as a permanent resident. But until you become a citizen, Mr. Speaker, you can't vote, you cannot participate in the voting process. I've heard students come in here and they get a Commonwealth scholarship, or we have students who are going overseas because they received a Commonwealth scholarship, and as such, you have those sort of relationships, and they should be able to vote. Mr. Speaker, we send students overseas to St. Thomas, for example, but they can't vote. We have a partnership with the University of the Virgin Islands. We offer scholarships to students to go to school there, but they are aware of the fact that when they go there, they do not qualify to become a registered voter there. And so why should someone, Mr. Speaker, who has come to St. Kitts or Nevis for the sake of attending university, simply after 1 year be able to qualify as a registered voter here? Why? You come here for the sake of getting an education, not to establish residency. For the sake of merely getting an education. And in my case, I didn't go to St. Thomas merely to get an education. I went there to live and couldn't vote. But you come here to go to school to get an education. Should you simply be able, after 1 year of attending classes here, go over to the electoral office and say, I want to vote here, and then you vote, let's say, in the election of 2020. And 2 years after, you finish school, you're gone. Can't get off the name. But you would have made, Mr. Speaker, you would have made a difference in some constituency. And you vote for someone who the persons are ordinarily resident in that constituency may not want. But they have to live with the choice that you made when you're going back to your country, Mr. Speaker. And we are saying that a criteria must be in place, and if you are outside of the CARICOM Commonwealth area, you must ordinarily be resident here for 3 years before you have that right. That is simple, Mr. Speaker. Not you establish a medical university, let's say in West Bastille, and so you build a dorm to accommodate 200-300 persons, and it's 200-300 persons, whether they come from India, Nigeria, some other Commonwealth country, and 300 of those persons end up on the list simply after a year. And it means that in that first year, you will have 200-300. By the time you get in more students, more of them become eligible to register, and then they graduate, they leave, the names there on the list, and you're having difficulties to remove them, Mr. Speaker. But apart from the difficulties to remove them, Mr. Speaker, should they be able to thwart the will of the people in constituency number 3?
So a Dominican can and a St. Louis can?
Is it right, Mr. Speaker? It is not right. And that is what we are speaking to, Mr. Speaker. Correcting, Mr. Speaker, some of those anomalies. We cannot allow them, Mr. Speaker, to continue forever. We are here to correct those things. The very same citizens of St. Kitts and Nevis that they have referred to, they have been speaking about these very same things year after year after year. Persons from across the political divide have been saying that we need to bring an end to these, Mr. Speaker. And Mr. Speaker, you listen to some of the members opposite, you would swear that it's only in St. Kitts and Nevis, Mr. Speaker, is that you have a residency requirement. In our case, we are saying 3 years. We heard mention of Antigua, Mr. Speaker. Antigua was mentioned over and over again. But what is the case in Antigua? In Antigua, the law says that you must be resident 6 months in a constituency in order to be able to register in that constituency. It also says, as a Commonwealth citizen, you must be resident 7 years. 7 long years.
No
7 long years before you are able to register to vote in Antigua. You look at Barbados. Barbados says 3 months in a constituency and 3 years in the country.
No distinction.
You go down, Mr. Speaker, St. Lucia. 2 months in a constituency if you're a citizen. But Commonwealth, 7 years
No distinction again.
in country. 7 years.
Substantive point.
7 years. 7 long years. And even if you want to accept what the senator opposite is saying, we are saying at least if you're from CARICOM, that we have certain treaties with, certain agreements with, certain free movement, for example, within OECS, in terms of CARICOM, movement of people with skill certificate, etc., Mr. Speaker, we are saying 1 year. 1 year. 1 year, Mr. Speaker. We are saying 1 year. That is what we are saying. Because we recognize that in terms of this particular region, CARICOM, OECS, we are basically moving into one in terms of integrating as a common community, one single community. That is the point, Mr. Speaker, that we are making. That is the point, Mr. Speaker, that we are making. I have heard questions being asked, Mr. Speaker. What if you go overseas to attend university? What if you go overseas for medical treatment? What if you go overseas as an ambassador? And those will be covered, Mr. Speaker, in the statutory rules and orders, because it is not everything that you spell out in legislation, Mr. Speaker. Legislation speaks to the substantive part of the law, the principal part of the law. And then, Mr. Speaker, you have the statutory rules and orders which would address those other aspects of the legislation. For example, Mr. Speaker, if you pick up the National Assembly Election Amendment Bill with all of the amendments which have been made over the years, you don't see in there that in terms of being able to object to an individual, this is the process, because those are covered, Mr. Speaker, in the SR&Os. And so those will be covered in the SR&Os. You go overseas as a student, you haven't moved from one constituency to the next. You go overseas to get medical treatment, you have not moved from one constituency to the next. The member for number one, Mr. Speaker, said, what if you go overseas for medical treatment? And I said to him, well then, register in the hospital overseas. Because you have not moved from one constituency to the next. The Act speaks about moving from one constituency to the next.
That is what she's saying.
Agent could say that.
Mr. Speaker, on the point of order, I rise on a point of order because I think the member who's having this room now is misleading his house. He's talking about someone moving overseas. The law says cease to reside.
I didn't say move overseas. I said students, medical treatment, etc.
Cease to reside, see here? That is why in the original. That is why in the original law before 1984 Constitution, every year, if you were not there, when the enumeration was done, you were removed. I was a student, I was removed.
Read the first part of the section.
You understand?
Read
So
the
that is
first
what
part of the
she's
section.
trying to say. Cease to reside.
Read the first part of the section.
Mr. Speaker, I rise on a point of order, because there seems to be a misreading of the bill. It says there, in the amendment, 37 subsection 3, where a person who is ordinary resident in St. Christopher and Nevis. This is not anybody who's moved overseas. This phrase is very much there. Where a person who is ordinary resident in St. Christopher and Nevis. There's nothing about moving overseas in that. It's only dealing with those who are here.
Registered as a voter for constituency.
Is to reside in that constituency. So you're a resident here, and you have to reside in this constituency.
What the law says, you don't say it.
But that's what it says here. I'm reading it.
It does not say that.
Let me read it again for you. Where a person who is ordinary resident in St. Christopher and Nevis is registered as a voter for...
You just read it.
But I'm saying it is
I
here.
believe that what you are reading, that is the intention.
Thank you, Mr. Speaker.
No, it says cease to reside. How do you explain that? Why don't you say it?
Mr. Speaker, I continue.
He doesn't say that.
And so, Mr. Speaker, I think the Honorable Attorney General, in his point of order, has made the point.
He doesn't say that.
You're ordinarily resident in St. Christopher and Nevis, and you're moving from one constituency to a next in St. Christopher and Nevis. Again, very simple, Mr. Speaker. Very, very simple. So you do not become disqualified because you've gone overseas for medical treatment. And when I responded to the member for number 1, he said, well, he hopes that I'm the matron for the hospital. Well, I don't know what he means by that because, you could have a female matron, you could have a male matron. So I really don't. That was a non-point like most of the other things that he said. Simple as that. Non-point.
He didn't say it that way. Don't try that.
No, but it was a non-point.
It was a point.
And so, Mr. Speaker, you send someone overseas to serve as an ambassador, that person still retains the right to vote in the Federation of St. Kitts and Nevis. You go overseas as a student, whether to UE, UVI, Cuba, Taiwan, wherever you go. You still remain as a voter in that particular constituency because you have gone overseas simply for that purpose. You haven't moved out of the constituency. You have gone to pursue studies to return to the Federation and hopefully to where you were ordinarily resident.
Because is somebody who is living overseas and domiciled here. That moved overseas. That not moved to another constituency. So we remain registered in the constituency was last in. You bought your clarity in 2007, 2008.
Mr. Speaker, again, I heard, well, if you move from one constituency to the next, because you have a girlfriend here, and so you want to register there, then, Mr. Speaker, it makes a mockery of the system. It makes a mockery of the system, Mr. Speaker, and there are 2 points I want to make on that, Mr. Speaker. In the first instance, Mr. Speaker, you heard from, I think, is the Honorable Attorney General. I'm a member of the Boundaries Commission. And in looking at the boundaries, one of the qualifications that one would take into consideration based on the Constitution is that it says there must be equality in terms of the number of persons residing in each constituency, persons who live here. And so, Mr. Speaker, if you think of the intent of that particular criterion, Mr. Speaker, it speaks to representing as close as possible an equal number of persons within a particular constituency. It makes a mockery, Mr. Speaker, of the system that we have here, where you have constituencies. For somebody to go here today, decide, well, I sleep in here for a week to 3 weeks, and so I can register to vote in this particular constituency. It makes a total mockery of having constituency boundaries.
Yes.
Total mockery, Mr. Speaker. And so, Mr. Speaker, you go, you have a child. You have a child. Okay, you have a child in Tabernacle. You have a child in Tabernacle. You go to Tabernacle because the child is living there. Does it mean that you have moved to Tabernacle, Mr. Speaker? It doesn't necessarily mean that you have moved to Tabernacle. And the second point, Mr. Speaker, even if someone is of the view that you have moved to Tabernacle and make an objection, Mr. Speaker, simply making an objection does not mean that your name is going to be removed from St. Paul's, because there is a process. There is a process. And many of us in here, we have been involved in that particular process. We go back to the point, Mr. Speaker, James versus Williams, and in that particular matter, the first part of the process isn't moving the court to hear the case. There's an objection process. The list comes out. You're able to make objections if you're already on the list. A big list comes out at the end of January. You're able to go through the list. You make the determination, is this person qualified to vote in this particular constituency? And anyone within the constituency can do it. So even as you listen, you get the impression that is members of parliament maybe trying to disenfranchise person. Anyone in the constituency, Mr. Speaker, can make an objection to a name appearing on the list. Anyone who is registered in that constituency. Let me make that point. And so, you go and you have a particular time in which to put in the objection. How many days after the list comes out? 10 days. So the list comes out the 31st of January. You have until the 10th of February to make an objection. There's a form that you complete. You put in your name, you put in your address, where in the constituency, you're eligible to vote. You put in the name of the voter, I think you put in the profession of the voter, and you state the reason as to why you are objecting to that person. And it's not just persons, Mr. Speaker, who may not be resident in the constituency. Someone has died, and the name is still on the list. That process also covers those individuals. And after you would have submitted that to the electoral office, sometime thereafter, notice is posted in the constituency of the persons who are objected to. Apart from that notice, mails are sent out to registered mails are sent out to the individuals at the address that they claim they live within the constituency. I understand they are now solved. So you're solved with that notice, Mr. Speaker. And you show up to an objection hearing. If you want to bring a lawyer with you to the hearing, you can bring a lawyer with you to the hearing. You can bring witnesses to prove that this is where you live. So you bring all that you can bring to prove where you live. And so you go through that process, and at the end of the day, the registration officer makes a determination as to whether or not you should be registered in that constituency. He may say no, he may say yes. And if you disagree with the decision, Mr. Speaker, you then move to the court for the court to make a determination and to give a declaration. So there is a process which goes further than the electoral office, a process which gives you the right to access the court if you feel that someone is trying to disenfranchise you from a particular constituency or being able to vote. Many cases have gone to court. The honorable member for number 8, he has had cases before the court. Plenty. Number 4. You have had cases before the court. So that when I heard the point, you're going to the electoral office, and if the person in there want to come out and see you, they're back there hiding. The only person that used to hide is a man named Parrott, who went into hiding after the elections of 2015. People in there hiding, they don't want to come out and see you. You have redress. There's a process, and the law outlines the process. You have the member here for Nevis, 9, who had a matter that went before the court too, to do with registration of voters and where they ought to be registered, and whether or not they had the right to be moved from one constituency to the next, etc. He can better speak to it than I can. But his matter also ended up before the court, for the court to give redress. At the end of it, I think you had to have a by-election in that particular constituency. The court is there, and the cases are there, the examples are there, Mr. Speaker, as to how the system ought to work. What we're here to do is to tidy up the system. And it is the voters out there, the residents of St. Kitts and Nevis, the citizens, who have said to us that these things ought to change. gave us a mandate, an overwhelming mandate. And that is why I've also said to those opposite, be careful. Do not be misled. Because the last person who misled those on the opposite side, they're no longer here. No longer here. And they would want to use that as fair warning. Mr. Speaker, it's as simple as that. We have criteria in place even to become a member of this National Assembly. There's a criteria in place. Mr. Speaker, he said earlier he came in here in 2004. By the election of 2010, I came in here, all pieces of legislation were being passed in here to say that when you got to be nominated, you have to sign this, and if it is you tell some lie, the registration, not the registration officer, but the returning officer can make a determination as to whether or not my name can go on the ballot. It was challenged before the court. So even though you come in here, you pass law, and persons think that the law is unconstitutional, you can go court. So if there are those who feel that what we are doing here today is unconstitutional, they can challenge it before the court. And so that matter went court. And the court decided the particular piece of legislation was null and void. The point is, Mr. Speaker, that they said I was in violation of the Constitution in terms of being a member of Parliament because I held dual citizenship. The United States of America and St. Kitts and Nevis. The Constitution says you can only have one citizenship to be here. And so I went and I renounced the US citizenship because that is what the Constitution says. In order to be able to become an elected member of Parliament. Fair enough. Mr. Speaker, the interesting thing is, the hypocritical thing about it, Mr. Speaker, the very same persons who brought the particular piece of legislation to Parliament was put out of the Parliament, Mr. Speaker, by the very court. Evicted. Like a common what? Like a common criminal, y'all say. That's evicted like a common criminal, Mr. Speaker. Evicted from the Parliament, Mr. Speaker. Because the very same person, Mr. Speaker, got citizenship for the country of Dominica, the Commonwealth of Dominica. A passport. I take it back. I withdraw. I withdraw. The very same person. He had sit down here when I asked him, you have a passport? He said, no. And I asked him again, he said, no. And when he said, Mr. Speaker, I'm being harassed. But ultimately, Mr. Speaker, the court determined that by virtue of having the passport, you're not eligible to be a member of Parliament. And so there's eligibility, Mr. Speaker. How do you become eligible to vote? You know, I heard the next argument, Mr. Speaker. I heard the next argument that because I'm from India or wherever I am from, I am just as responsible as other persons. Well, then should we make the argument, Mr. Speaker, is that at 17, I'm just as mature as the person who is 18, and so I should be able to register to vote, Mr. Speaker? Pardon? Exactly. So should I make the argument I'm just as responsible? I could be 16, 17. When I finished with high school, I was 16. You could be 17 out there working, paying social security, establish a business, etc. But it doesn't mean that you can vote. You become eligible to vote at the age of 18. Qualifications. What is wrong, Mr. Speaker, with having qualifications? That is what we are saying. This is how you qualify to vote. If you're a citizen, immediately upon turning 18, you're able to register. You're from within the CARICOM area. You have been living here not for 1 month, not for 2, 3, 4, 5, 6 months, but for 1 year, you are able to register.
And then not being discriminated relative to those who are born here.
No, no discrimination.
Except if you're from Ghana.
If you're from outside, if you're from outside the CARICOM area, then you must be here for 3 years in order to qualify to become a voter. Those already on the list, they remain on the list. But if you aren't on the list as yet and you don't go before the law is gazetted, then you have to wait until you're here for 3 years. And as I said, Mr. Speaker, we are 4 years and 8 months out from an election. So, maybe you know something I don't know. And I could understand you want to get rid of the leader of the opposition, so you would want the election soon. I could understand that. I can understand that. Pardon? Who's please? That's what I said, yes. Okay. So, Mr. Speaker, 4 years, 8 months. So even if when the borders open, at the end of October you come in, you continue to live here, you have 3 years from now, this 2020, October 2023, you become eligible. Because in the election before then, we're building a stronger, safer future. The people of the Federation of St. Kitts and Nevis gave us a stronger mandate to build a stronger, safer future, and that is what we are concentrating on. I recall when we came here with the piece of legislation to deal with the state of emergency. Man, you had one set of noise coming from the opposite benches. We put in state of emergency in place because we want to call an election and we want to do this and we want to do that. And we ain't calling the election until June of 2020. And when we called the election, the very same people say, they went to the court, they said, me not ready yet. They were up and down ringing bell. You say, if we ain't ring the bell, they're going to ring it. And when we ring they had 1 week. Huh? They had a kettlebell, the member for number 2. So you don't know what kind of bell it is. You know, sometimes when you play masquerade, I don't know if the masquerade got them little bells on them still. I be what kind of bell they had. Not a soul hear the bell. And so the election, I'm not mocking the culture, I'm saying those little bells, it is like one of those little bells that they had. What about that is mocking the culture? Man, you sound like say after me. Sound like one of those little bells. Yeah, I know the bells that they used to go and the masquerade thing them. Could I hardly hear it? Come like it's one of those bells they had. And so by the time the election come, they made history. See, that they never lose before. They lost. Never lose the West Bank. Must be that's what you say when the results came. And see, that they never lost before for the very first time in the history of adult suffrage. They lost the seats. When you say weak leadership? Weak leadership, some say. And so, Mr. Speaker, I think I have said enough on this particular piece of legislation, Mr. Speaker. The National Assembly Elections Amendment Bill 2020. Mr. Speaker, I am fully supportive of this piece of legislation. And as such, Mr. Speaker, I wish it safe passage, and certainly I will be voting in favor of the legislation being passed in this National Assembly. May it so please you, Mr. Speaker.
Thank you, the Honourable Member for St. Christopher 5, Mr. Sean Richards. I recognize the Honourable mover of the bill, Prime Minister Timothy Harris to do his reply.
Thank you, Mr. Speaker, for the opportunity, Mr. Speaker, to wrap up the debate. It has been a long and eventful day. None of us would have predicted that a bill so simple and clear in terms of its objectives would have had members tarrying for so long and tarrying in irrelevancy as it relates to the bill. And it is unfortunate, and yet it is part of the rich democracy that we practice, that at times these extremes are allowed. Hopefully, Mr. Speaker, the opposition will come to the next debate better prepared. I recall as I listened to some of the presentations coming from members opposite, some new members, and at least one old member, experience in the Parliament. And you listen to them and you wonder, why are they saying these things? And I reflected when I heard the first presentation from the senator opposite. Wow, that sounds just like Marcella. And why Marcella, you may ask? Because Marcella Liebert had the pattern, sitting in the same chair, had the pattern of coming into the Parliament. Whatever the bill was, had no meaning to her. She came as if she was going to shop, and she had a list of things that she will speak about. No matter the context of the debate, she will speak to those things. And when she is finished, she will call out all who is dead, and then she leaves the Parliament. A pattern of coming to Parliament, not prepared to stick to what the Parliament is about. And indeed, when you look at the standing orders, they are appropriate areas in which members of the Parliament can intervene if they wish to raise certain matters. But you can't use a bill to come in the Parliament and all we are hearing is children melee. Can't use that. And the Parliament must ensure that that kind of behavior, practice as it is from the opposition, does not continue too long in this session of the House. And yes, we pardon and we excuse the newness of the member for number 1. We excuse the newness of the lady senator opposite. And you ask yourself, after 4 months of a general election, where is the parliamentary caucus for the old Labour Party? Where is it that members come into the Parliament ill-prepared, not having read the bill properly, and so they go off in all kind of things, unrelated, no distinction between what is a matter of legislative importance and event and what in fact is a matter for executive action. For some of the things they talk about, we hear the conversation about we need some computers in the school. That's not a matter for legislation, that's not a matter for here. We hear a long list of things that may be wrong at Keon High School and nothing about what is right at Keon High School. And you wonder, has the teacher reported those to the principal of the school? Has the teacher reported those to the education officer attached to the school? Has the teacher written to the chief education officer? That is what the teacher should have done. And then we would not have been laboring in the Parliament about these matters, important as they must be, not a matter that is of any relevance to the debate. These things are what keep us here so very late. Because they are using every occasion to attempt to score cheap political points. Political points. But that is not what the Parliament is about. Certainly you could go on Freedom Radio and talk some of those things if you wish to. But when you come to the Parliament, there are specific matters put on the agenda for which they opposite are given 7 days notice. 7 days to alert themselves. And they are given the bills to read and prepare themselves. Imagine we come here. They come here. I want to make the point. And we hear conversations coming over there, and they know better. Well, this bill is rushed. I think the Deputy Prime Minister dealt with that particular falsehood adequately. Suffice it to say, it was since August. Since August, the member for number 1. Since August, the member for number 6. Since August, the senator opposite had knowledge of the bill. The bill we are debating today. It was with them for 4 months. 4 long months. They did nothing. They held no party caucus. They held no meeting with their constituents. They didn't send it to the youth parliamentarians if they wanted an input from them. They didn't send it anywhere. And after 4 months, they come to talk about this is rush. Laziness, why they didn't read the bill. Laziness, why they come into the house ill-prepared. And to cover up their shortcomings, they sought to get into all kind of irrelevance. The country of St. Kitts and Nevis knows what rush means in the context of Parliament. That is why the member for number 6 is over there. Because we the people understood what rushing in Parliament meant with respect to legislative action. His last piece of legislative enactment and government side, was with respect as the Prime Minister and a member of the government, was in January, 16th of January. That is your birthday or 2 days after. After his birthday, he came into the Parliament on a Friday to it. And within less than a half an hour, as the Boundaries Committee had met and deliberated on the boundaries, he rushed it into this Parliament to be acted upon. Rush, spell it with a capital R. Spell it with a capital R. And in order to ensure that it was rushed through the Parliament processes, he had the gates down there locked into entrance into the government building. We had to call, made a big noise to get entry to come into the Parliament. Gate locked, streets barricaded.
That is not true. That is not true. On a point of order, he's misleading the House. No gate was locked.
The gate was locked. You were there when I came in? You were there? The gate was locked.
The member for number 5 was there. Everybody came. There was no gate locked. That is absolute nonsense.
We had to make.
In the House.
We had to make requests. We had.
Properly.
All right. When you finish shouting.
I am not shouting.
Okay.
I am here on a point of order. You are misleading the House.
Honorable
You are
member.
lying to the House.
Mr. Speaker,
Honourable members,
that's not a point of
no,
order.
honourable member for number 6, you should not be saying that. That's a simple matter for me. The member presenting claims when he came, the gates were locked. Somebody has interjected and made a valid point and asked if you were there when they came.
Of course I was there.
So it's the member said it.
No, that
Honourable
again,
member,
states.
honourable
Gate
member,
was not locked, Mr.
honourable member for number 6. I still insist that to me it's a simple matter that the member presenting is claiming that when he came to government headquarters, the gate was locked downstairs.
That is not true.
Someone has interjected and said you were not there at the time he came, so you are not in a position to speak to.
Working hours. Civil servants when still there.
Anyway, let's move on.
This is, Mr. Speaker, he seemed to forget, Mr. Speaker, that whenever there was a parliamentary sitting, all of Church Street became a sterile area. All of Church Street. No cars. The SSU and rooftops. The SSU in the parliament, ready for action. Customs come prepared. A selected group of them. That was what we had in our country. Democracy was being made a mockery of. We know, Mr. Speaker, that is why he told the member for number 8 on that very day that he should be thrown out. Well, he told the Speaker, throw him out like a common criminal. This whole we had matters when they are being rushed. The member must not be allowed to speak. He should be thrown out like a common criminal. So, Mr. Speaker, there's nothing rushed about what we are doing. The member for number 6, as forgetful as he may be at times, did recall in the crosstalk that we brought legislation before in the session before this one of the Parliament to deal with matters of electoral reform, to deal with matters, he said, to do with the overseas voters, and we did lay in the House for first reading a bill in relation to that. So there's no secret. There's no rushing of it. We did not go through with it because they made the point that it was too close to an election to be bringing those things. And we recognize that it would not be good. Whether we brought that bill or we didn't bring it, it was clear to us that they were going to lose again. Lose again. And they did. And they did. Bigger. They lost bigly, Mr. Speaker. They really did. So this falsehood about rushing through, why are we rushing? There's no need to rush. And the evidence of Jews speak clearly that since last year, they know that a bill like this was coming. 4 months ago, we gave them the bill. They were aware of it. And they come to the Parliament and they're mixing up so many situations. They talk about disqualifying people. They seem to forget, that the bill that we have brought here was dealing with three things alone. One, it established 2 categories of Commonwealth citizens who could become qualified to vote. And it established, secondly, 2 criteria with respect to residency. That's what the bill do. It says, if you are our brothers and sisters from a member state of CARICOM that is part of the Commonwealth, we will allow you to continue to wait for 12 months before you are able to register. You qualify to register. no controversy. That is now the law. And we say we appreciate that these people are our own people. They are our kith and kin. They are our brothers and sisters. We share many things in common with them. The same geographical space, the same culture, the same history, the same cricket team, so many things, the same central bank, the same university, the same court, and we could go on and on. We order our health products through the pharmaceutical program of the OECS. We harmonize our foreign policy, and that distinguishes them from the others. That's what it is. That's it, what it is. They are given special and differential treatment. And the doctors who say that they understand globalism, well, special and differential treatment is still on the agenda. Not all countries are treated the same. There will never be. At the United Nations, perhaps the most equal of international organization in terms of an ability to participate at the level of the General Assembly. When you go to the Security Council, some are there and some are not. And even within the membership of the Security Council, you have the permanent 5. You can't touch them. And you have the others. The permanent 5 have de facto power to veto. So if Russia says no, if America says no, it doesn't matter what the other 190 plus other member states of the body says. Because at the level of the Security Council, they distinguish the power brokers. That is a reality of life. That will never change. We will come here, and one of the bills we are going to be dealing with talks about harmful taxation. Well, different world. Who among the OECD is going to call upon the United States to change up their fiscal policy and to make changes to tax law? Who? No one can. No one can. And yet, the OECD says it has the authority to discipline and to blacklist countries. Can't blacklist Mr. Trump, America? They can't dare do that. They can't blacklist Germany. Because in the global world, power makes a difference. And so, a lot of times, as is the case with Antigua, Antigua goes to the WTO, World Trade Organization, wins its case in relation to internet gambling, and up to now can't get a settlement. Power talks. Countries are different, and we will not all get the same treatment. So those who allow themselves to get sidetracked by the theory of we are a global world, let them come. When you begin to analyze it, you see how ridiculous the argument becomes. Let them come. A country with 55,000 people, a population, and many of them not even Kitishans and Nevisians, by birth, by marriage, or residency, but part of the inhabitant base of the country. And you say, let everyone from India, or whomsoever will, 1.3 billion persons automatically then get access. How does that make sense to anybody? Whether you're a doctor or a teacher or a lawyer, that such a policy could stand. But you say, let them come, don't discriminate, give them the very rights that we who born here, we who have no other place but St. Kitts and Nevis to call our own. We have no land to go back to when all is lost. They can go back to India if they will. They can go back to Fiji if they will. They could go back to their country of birth. We have nowhere to go. We have no Dominican diplomatic passport to show to the world at Gatwick. We don't have. So we say we have to be careful that we do not displace our own citizens here. And we make no apology, none whatsoever, for preserving the power of Kittitians and Nevisians in our space. We hear the member for number 6 says, well, the people are investors. Let them vote. Is that what the franchise fought so hard for by those before us? Is now the mean too? Because he or she can invest, they must get the right to vote. Just so. And we say over here, no, no, no. The money must not become the influential and decisive factor in determining who can vote in St. Kitts and Nevis, because history would record it's from there that we came, where it was only the propertied class, the white planter man and his offsprings and his friends were able to vote in St. Kitts and Nevis. And we had to have had riots in our countries. Buckley's riot, riots in Jamaica, the Moyne Commission, social and political reform that led in 1952 for the first time. Member for number 6, try and control your phone. Huh? I know the technology is new. Tell me when you got through with it so I could continue. Yeah. So, Mr. Speaker, that is where we have come from. And it must be disappointing that members opposite come today to put forward that offensive view. There is no merit to that, and it has no place in a modern St. Kitts and Nevis. They talk the falsehood about persons being thrown off the list. Again, the point had been made by the Attorney General and the Deputy Prime Minister and member for number 5. Nothing tall goes so. In fact, the law protects at clause 39 the right of a person to remain registered. And it sets out the process, the very process that the senator is unaware of, the very process that the member for number 1 is unaware of. It is written in the bill. Written in the bill. And they must look at the section 39, section 45, section 52. And they would understand that the point they were trying to make really, there was no need to go there because the law is quite clear. And just some advice, Mr. Speaker, because again, you go back to the story. Do you understand what you read, member for number 1? No, because I am new. Do you understand what you read, senator opposite? No, because I am new. And even if I am not new, well, I am a doctor. What does a doctor have to do with that? The arrogance. The arrogance. Don't tell me because I am a doctor. Well, I am a doctor too, but me can't give injection. I have to listen and understand. I can't give prescriptions. So there are certain things you are exposed to by training and experience, but you can't profess to know it all in the world in which we live. It was unfortunate that we would hear that conversation. The bill, Mr. Speaker, is a very important one, and the Attorney General made mention of it. At the heart of it, really, is for the people of St. Kitts and Nevis and all who live here to experience real democracy at work. Real democracy as it was intended and is intended to work in the Westminster Parliamentary representative system. That you vote where you are registered to vote, and you should register where you live. You can't be in St. Paul's and still voting up at Boardwalk. It is wrong. You can't come to our country in transition and believe that you're here 1 semester, 2 semester, 3 semester at Windsor or any other institution of learning, and you will be able to vote here, just like Marshall Lewis in Sandy Point. It's not fair. Just like the young man, Kevin Williams, it's not fair. Just like Jeffrey Hanley in number 1, it's not fair. It's not fair. It patronizes. It brings an aberration to the practice of democracy. And I ask each member opposite, tell me which country you can go to. Tell me which country you can go to, not being a citizen and being able to vote just so without a residency criteria. There is none. It wouldn't happen in Putin's Russia. It certainly will not happen in Trump's America. It will not happen in Boris Johnson's United Kingdom. Why is it they figure that small little St. Kitts must allow those aberrations to happen? We are better than most. We are better than most, and we value and we take pride in our ability to manage our democracy. And so, Mr. Speaker, I want to commend those on this side of the House for their contributions, and to say to the members opposite, we are hoping in this particular session of the Parliament that the Honourable Speaker will organize for a number of courses, training sessions that will better prepare parliamentarians, especially new ones, on both sides of the House, really, to give them an orientation into parliamentary life and how they should approach Parliament. Indeed, I think the Clerk of the House had made such a proposal for consideration. That is where we really need to go. We hear them say, in their hypocritical way, why early with electoral reform? But you recall during the lead up to the last election, they were asking the same question. They were saying Timothy Harris waited the last shower of rain and he wanted to deny those people overseas the right to vote. Why he didn't bring it early? Well, now we are very early. Over 4 years before an election is constitutionally due, save as the option of the Prime Minister. And they are saying the same nonsense which they spoke then, that we are rushing. We are giving people time to familiarize themselves with the new law and to make the adjustment. We certainly can't be accused this time of coming in the last shower of rain. We are doing the right thing for the country. And when we hear such things about people having multiple places of residence, some short-term. And these must be factored into the law. We say no appropriate law will be able to cater to the whims and fancies of every resident in the country. Member for number 5 spoke about it well. So what if she lives in Molyneux? What if her grandmother is in Challengers? She determines, well, I'm going to be there, spend a little time there with my grandmother. And if I want to, I must just vote in number 4 because I want a different candidate in number 4. We can't allow that. Can't allow that at all. We hear what is the agony of the member for number 6. And it is really with respect to the third element of electoral reform. You must vote where you live. And he recalls that over 200 plus persons from St. Paul's were encouraged to go into number 4 so that they could be available for the displacement of the representatives there.
Warriors already assigned. Warriors already assigned.
Warriors already assigned. And we say this is an unhealthy and illegal practice. And today we come to make sure that it will not repeat itself. That is their worry. They want to be able to conveniently pad the list. They want to have a situation where you vote where you want. As he would say, nobody could stop you. So if we have a by-election in number 1 soon, then nobody could stop you. Go and register in number 1, although you live in St. Paul's, although you live in Sadler's, although you live in Parsons. Hundreds of persons from number 6 sent all around, specifically to ensure a particular outcome. Even in number 7, they waste time and they send some, because the handful they send up there can't really make a difference in number 7. Can't make a difference. But they are vulnerable seats. Seats that historically will always be competitive, like number 4, number 1, number 2. They have always been competitive. And he believed that by strategically maneuvering the residents, that he would be able to determine the electoral outcome. This bill is intended to say no to this kind of misbehavior and to allow us to have a better practice of democracy. In closing, Mr. Speaker, I want to commend the Attorney General and his officers for being able to crystallize these elements in our first effort in this session of the Parliament to bring genuine electoral reform. And there's no need for referendum. The people have just voted. They voted 9 in favor of the government of Team Unity and 2 to the opposition. But that is a clear referendum. Why are you going back? That is like going for your visa before your time expires. If you're not careful, the marks cancelled in it. Why are we going to a referendum when we just won an election, where we put electoral reform as one of the things that we will do? And we came out victorious. Why go to a referendum when the Constitution does not require it? Why waste the public money again Because going to the referendum is like doing over another general elections. It's about spending time going to canvass a point for which we already know the answer. Why go to a referendum again to spend those money again? For them to cry that they are not ready again, for them to lose again, for them to go to the court again, for them to say, well, we have COVID-19 and we have a state of emergency. Why Dr. Harris call a referendum again? Doesn't make sense. And they know it. They are not prepared. We hear that we need to have COVID education. Well, education is an ongoing process. We never have it all and we never know it all. We have to always engage in a process of learning, even when you're a doctor, and unlearning some of the things that we have already learned. That is why almost every week we have at the NEOC. How often they have these sessions? Every week. Talking about COVID-19. Superintendent Henry, the CMO, Abdia Samuel, Dr. Wilkerson, Lesroy Williams, all of them have been engaged in a practical activity of preparing and training our people from way back since March. Our people understand. That is why when John Paul calls in, John Paul said, with people in St. Kitts, now listen to the news. Because when you listen to the news and CNN and Fox and BBC and Sky, the Gulf News, Al Jazeera, all of those, you can't hear a news session without information regarding COVID-19. What they must do is by example. Show the people that we can live safely with respect to COVID-19. And the fact that in our country we have managed to do so well that when the international media wants to interview someone to reveal a success story in the management of COVID-19, they look to the Prime Minister of St. Kitts and Nevis. Whether it is BBC or Sky or CNN or CBS or in the Gulf. Next week I'm doing one with the largest circulation in Nigeria. Because we are a success story. Our people understand. The majority of them understand what is at stake, Mr. Speaker. Yes, Mr. Speaker, we have done well. And there will always be room for improvement. I hope that at Keon High School, where the senator is, she is doing what she can to help our people understand and appreciate more with regards to COVID-19. And it is not a perfect world. It is of no consequence in today's world as it is for the teacher to come to say, well, the students, they don't have a device, so the students can't learn. And the students do not know what is happening. We will reject that for what it is. The politics, for that's not real. We learn, and there were no devices. We learned, even when there were no physical schools. I recall at Tabernacle, we had classes with teacher Susanna Lee under a tree. Under a tree. We had our classroom, yes, but some of the classes were outdoors. And we learned. Sometimes we encourage children to put emphasis on the wrong things. You go to many countries, You see their sports facilities. Man, they're playing football and rough dirt. No nice field like we have at Warner Park or St. Mary's or Sandy Point. No nice field, well prepared. And people from those very humble settings have emerged internationally. And you wonder, we put too much emphasis at times on the material things. We hear in this debate talking about irrelevancy. Well, what about the marketing plan? Well, I've heard Raquel Brown, the Director of Tourism, spoke to the marketing plan for tourism. There are things on the tourism website, but this debate wasn't about it. As the Deputy Prime Minister says, when the budget debate comes, we could have a conversation about that particular matter. We have heard about the school meals. Truth is, school meals. The school meals program is better than it was under the Douglas administration. And more students and more teachers are now participating in the program because the quality has been enhanced. And even during COVID, we provided that and made it available so that our people and our children in particular would not go hungry, and to ensure that at least they would be assured of at least one hot meal per day. The government is not indifferent. It is because we have not been indifferent, and in fact we have been compassionate and sensitive, that I unveiled the largest stimulus package in the region. Smallest country in the Caribbean, with the most comprehensive stimulus package. In some, absolute. In some countries, they're giving $600. In some countries, they're giving $330. In some countries, they give none. And Deputy Prime Minister got himself in trouble because he said in one country, which shall remain nameless, they had no stimulus package. For the record, I'm not saying after the Deputy Prime Minister. Every country will look after its people in accordance with its resources. But here in St. Kitts, what a marvelous job we have been able to do. Here in St. Kitts, in addition to that, we came forward, we have more social safety nets than any other country. We have a PAP program that has pumped over $20+ million for the year so far to people who are having an income below the 3,000 threshold. During this season of COVID, we, as it were, relaxed it, and 1,940 persons, I reported last Tuesday night, and Leadership Matters were able to come onto that program. So you had stimulus money, you had PAP money, and you had other money, and you still have voucher programs at Eugene Hamilton's ministry, Social Development. In fact, right now, the conversation in the country is, why should some be getting PAP? They're getting stimulus and they're getting their severance. And we have agreed that we need to rationalize it to ensure that it is really the most needy who are getting these benefits, so that the disincentive for persons to go to work no longer carries in the future. Because if when they had the PAP and they had the stimulus and the severance and all those other social safety nets, they then say, well, boy, what is sense I going out to work when I get in all this easy money? And that will not be good for our country and our productivity. So I want to end now, Mr. Speaker, again in thanking all who have contributed to the debate. The opposition, I want to thank them, although they were irrelevant in material particulars. But again, they gave us an opportunity to correct their mischief right here in Parliament, rather than await for the lies and half-truths to be announced on Freedom Radio and on social media. I want to say that the citizens of St. Kitts and Nevis are our primary concern. Whether it is with PAP or stimulus package and so on, we want the very best for the people here. And I want, yes? COVID protection. And I want to say also that there must be a special place in our country for our brothers and sisters from Antigua and Barbuda, from Dominica, from St. Vincent and the Grenadines, from St. Lucia, from Jamaica, from Guyana, from Trinidad, from Belize, from Haiti, from all the member states, really, of CARICOM and OECS. The truth is there is a special bond and relationship, and it pains me that members opposite pretend not to be able to appreciate why we want to be nice to the people of Guyana, why we want to be especially nice to the people of St. Vincent and Dominica and Jamaica, why we want to be so nice to them, why not treat them like the citizen coming from Fiji, why not treat them like the person coming from Malta and Vanuatu and the Solomon Islands. And we say we can't. We can't, because the special bond is not there. Additionally, we say that there are legal reasons. The treaties of which we are a part, the CARICOM Treaty, the Treaty of Bastille related to the OECS, demands that we give special and differential consideration with respect to nationals from those member states. Notwithstanding, Mr. Speaker, the arguments put forward, we have an excellent piece of legislation to work with, and we will come again to deal with other issues related to electoral reform. So I want to thank the country for their support for the government, thank them again for giving us the mandate to effect change, and I want to wish this piece of legislation safe passage to the Honourable House. Thank you, Mr. Speaker.
Thank you, the Honourable Mover of the Bill, Prime Minister Harris. I'll put the question for the second reading of the bill. The question is that the bill entitled the National Assembly Amendment Bill 2020 be read a second time. Those in favour? Aye. Those against? The ayes have it.
A bill to amend the National Assembly Elections Act, Cap 2.01, otherwise known as the National Assembly Elections Amendment Bill 2020.
The bill has been read a second time. House moves into committee.
Clauses 1 to 5.
The question is that clauses 1 to 5 stand part of the bill. Those in favour? Aye. Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favour? Aye. Those against? The ayes have it.
The title,
The question is that the title stands part of the bill. Those in favor? Those against? The ayes have it. House resumes.
Mr. Speaker, sir, I rise to report that the bill entitled the National Assembly Elections Amendment Act 2020 has gone through committee stage without amendment, and I therefore request that the bill be read a third time and be passed into law.
Mr. Speaker, I rise to second the motion.
The question is that the bill entitled the National Assembly Amendment Bill 2020 be read a third time and passed. Those in favor? Aye. Those against? The ayes have it.
a bill to amend the National Assembly Elections Act, Cap 2.01, otherwise known as the National Assembly Elections Amendment Bill 2020.
The bill has been read a third time and passed. Next item, please. Yes. Is that the resolution to establish the committee? Okay. Thank you. Thank you. Next item, please.
Motions, resolutions,
Mr. Speaker, I rise to have read before this National Assembly a resolution entitled Resolution of the National Assembly of St. Christopher and Nevis, made under Section 65 of the Standing Orders of the National Assembly as set out in the fourth schedule of the National Assembly Elections Act, Cap 2.01. Did first. Mr. Speaker, this is a resolution which is brought to establish a select committee of this national parliament, made up of members on both sides of the aisle. The resolution is intended to establish such a select committee for us to review the standing orders that we are governed under. From time to time today, you, Mr. Speaker, have had to refer to those standing orders and have had to intervene into the debate and to the general conduct of this House. It is critical that we, from time to time, review these rules to ensure that this Parliament conducts itself in the proper manner. Mr. Speaker, I will read the resolution into the record, if you mind. Whereas it is provided by Section 65 of the Standing Orders of the National Assembly, as set out in the fourth schedule of the National Assembly Elections Act, that the National Assembly may appoint any of its members to be a select committee for the purpose of examining and reporting on the clauses of any proposed bill or for any other purpose. And whereas the National Assembly may appoint a chairperson of a select committee, and in the absence of that appointment, then the select committee shall appoint its own chairperson. And whereas a select committee shall be constituted in such a manner so as to reflect, as far as possible, the balance of the parties in the National Assembly, and shall make a report to the National Assembly upon the matters referred to it. And whereas the National Assembly considers it necessary to appoint a select committee to review the provisions of the standing orders of the National Assembly, now be it resolved, therefore, that the National Assembly of St. Christopher and Nevis hereby approves the appointment of a select committee to review the provisions of the standing orders, and the composition of the committee shall be as follows. The Honorable Eugene Hamilton, Leader of Government Business, Chairperson. The Honorable A. Michael Perkins, Speaker of the National Assembly. Honorable Eric Evelyn, representing the government. The Honorable Dr. Jeffrey Hanley, representing the opposition. And the Honorable Dr. Joel Clark, representing the opposition. Mr. Speaker, this is a very straightforward and simple resolution, but is timely. It is important that we consider all aspects of the conduct of this Parliament. We often have heated moments. We often, while doing the people's business, go off the rails, and we have from time to time have the Speaker be responsible for guiding us so that we can get to have proper debates and to exercise our democratic rights, and to be able to have our people feel as though they are being involved in what we do. Mr. Speaker, I commend this resolution to the House. May I please, Chair?
Mr. Speaker, notwithstanding that I'm named in the resolution, I rise to second the motion, and in doing so, to indicate that this committee had been formed during the last sitting of Parliament, but time overtook the work of the committee. Indeed, we did some work, not without our challenges, but we had drawn from and will continue to draw from the best practices in the region in putting together any report that is to be considered by the Parliament. And so I do support this resolution. May it please you.
Thank you, honorable members. Would anyone like to speak to the resolution? If there are no other input,
Speaker, I rise to lend my support, of course, to the commissioning of this particular commission. I think the standing orders have been relatively, I wouldn't say archaic, but they need to be modernized. And I believe that it's good that this is taking place at this time. I wish that the committee will be able to do its work in a very timely manner and also in a very comprehensive way, so that we can bring the standing orders of this Parliament in line with not only what practices are pursued in modern countries, but in particular here in the region. May it please you, Mr. Speaker.
thank you very much, honorable member, for number 6. And just one small point I would like to highlight. One of the reasons it has become necessary for us to seek to revise and update our standing orders is, for example, our standing orders at this time do not speak to the transmission of information to members electronically, even by emails, and so that in itself at times create difficulties. And so that clearly would be one of the amendments and improvements we'll make going forward, that the standing orders would provide for the transmission or the distribution of information electronically. And so that's just a simple point I wanted to place on record to indicate the necessity of us doing this exercise. Having said that, I will put the question for the approval of the resolution. The question is that the resolution as read by the Honorable Vincent Byron, Attorney General, to establish a select committee of this National Assembly is hereby approved. Those in favor? Aye. Those against? The ayes have it. The standing committee to review the standing orders of this National Assembly is hereby established. Next item.
Mr. Speaker, I rise once more, with your leave, to read and have debated and passed a resolution of the National Assembly made under Section 19, subsection 7 of the St. Christopher Nevis 1983 Constitution Order. Mr. Speaker, earlier today, under the rubric of statements by ministers, I made a short but important statement to this Honorable Parliament, in which I indicated that there had been a judgment of the High Court handed down this morning, in which His Lordship, Mr. Justice Trevor Ward QC, indicating that the state of emergency, the resolution creating a state of emergency that was passed in this National Assembly on the 18th of April this year would had stood scrutiny against a claim brought by 3 members at that time on the opposition benches, the Honorable Marcella Liebert, Congress Maynard, and Right Honorable Dr. Llewellyn Denzel Douglas, and that his lordship had found and that there was no merit in the declarations being sought by them to declare that the state of emergency was null, void, and of no merit. I indicated in my brief statement, Mr. Speaker, that the 6 months that that resolution or that state of emergency had been intended to cover expires on the 18th of October, that is on Sunday coming. Earlier today, the Honorable Prime Minister, member for number 7, had indicated in this Parliament that this government would be opening the borders on the 31st of October. But our country is still under a threat of the coronavirus pandemic, COVID-19. And there have been a number of regulations that have been passed since the state of emergency was first introduced by His Excellency, the Governor General, Sir S.W. Tapley-Seaton, back in March of this year. It was at the expiration of 21 days after that that proclamation had been made by His Excellency that we had found it necessary to come to Parliament to extend the state of emergency. We now find it necessary, Mr. Speaker, to extend that state of emergency for a short window as we move over the next few weeks to have a second reading for the COVID Prevention and Control Bill that had its first reading before this House today. We find it necessary to keep in place the state of emergency during that period. We find it necessary for the current statutory rules and orders, SRNO, that is in place covering the regulations under the Emergency Powers Act to be extended during that same period. It is open to this Parliament, to this National Assembly, to return at any time to revoke this resolution or this state of emergency by resolution once we would have passed the COVID-19 Prevention and Control Bill, and we are satisfied that the measures that it has covered and the regime that it is intended to establish works to protect all our citizens. We understand that there is concern in the country, that there's some trepidation that while we open the borders to help to move further economic activity, while we open the borders to allow us to slowly start, to jumpstart the tourism sector that has been so badly affected by the closure of our borders by COVID-19, that this is a way in which we can continue to maintain a measured control. We have heard from those opposite during the course of the day that they want to speak about COVID-19 and that we need to understand the concerns that people have. And this resolution, Mr. Speaker, is a way for them to put the money where their mouth is. And we hope that they will support the extension of this resolution over the next 2 months or so to be able for us to have the COVID Prevention and Control Bill properly passed into law and implemented. It is a stopgap measure for a short window, and we hope that we get full support from this Parliament for this extension during the course of the resolution. Mr. Speaker, I would want to read the resolution into the record. The resolution of the National Assembly made under Section 19, subsection 7 of the St. Christopher and Nevis 1983 Constitution Order. Whereas by virtue of the provisions of Section 19, subsection 1 of the St. Christopher and Nevis 1983 Constitution Order, as set out in the 4th schedule to the West Indies Associated States Act, Cap 1.01, the Governor General may, by proclamation, declare that a state of emergency exists in St. Christopher and Nevis for the purposes of Chapter 2 of the Constitution. And whereas, by virtue of Proclamation Number 6 of 2020, dated 28th March 2020, the Governor General declared a state of emergency for St. Christopher and Nevis for the period 28th March 2020 until 11th April 2020 on the ground of the threat of a natural calamity of the COVID-19 virus, an infectious disease which had taken effect on a pandemic scale and which threatened the Federation of St. Christopher and Nevis, and whereas the said state of emergency was extended until Saturday, 18th April 2020 by Proclamation Number 11 of 2020, dated the 7th day of April 2020, and whereas the state of emergency was extended by resolution of the National Assembly, dated 17th April 2020, for up to 6 months, which time period is scheduled to expire on 18th October 2020, and whereas, pursuant to Section 19, subsection 7 of the St. Christopher and Nevis 1983 Constitution Order, a declaration of emergency may be extended by resolution of the National Assembly for a period of 12 months or such shorter period as may be specified therein. And whereas it is further provided that pursuant to Section 19, subsection 8 of the St. Christopher and Nevis 1983 Constitution Order, a resolution of the National Assembly for the purposes of subsection 3 shall not be passed in the Assembly unless it is supported by the votes of not less than 2/3 of all the representatives and senators. And whereas the ongoing threat to St. Christopher and Nevis of the incursion of the COVID-19 virus, an infectious disease on the scale of a global pandemic, continues on an unprecedented scale with millions of persons being infected worldwide. Now, therefore, be it hereby resolved by this National Assembly that as a consequence of the serious nature of the continued threat of the COVID-19 pandemic to the public health of St. Christopher and Nevis, that is necessary to extend the state of emergency from the 19th of October 2020 until the 31st of December 2020. Mr. Speaker, the government is very mindful of the need to be careful as we extend the state of emergency. We understand that we have, over time, over the last few months, been able to gradually open up the country. We have slowly extended the time for curfew, or reduced the time for curfew, the lockdowns. These have been removed. The country has opened up, but there had been a need to continue to maintain some measure of control, and the state of emergency did just that. We are now, as I speak, in a situation that although there still is a state of emergency, there's no curfew, there's no lockdown, that citizens, for the most part, can conduct their business, even though there is still this threat that at any time there could be an incursion, a transmission of COVID virus among our people. And there's deep concern that such a transmission could affect communities around St. Kitts and Nevis. That community spread may have people have to be admitted to special conditions in our hospital setting, that there's only a limited number of beds available that can so cope with this very serious threat to public health, and that we have a very small public health sector that could be inundated and can lead to a paralysis in our country. The state of emergency does give to our medical team, does give to those who continue to advise, to work to have people comply, the tools by which we can ensure that our people are protected. And as we go over the next couple of weeks to move to open the borders, the state of emergency will not interfere with that, but will allow our medical teams, our security forces, our task force to be in a position to administer our response to COVID-19. Mr. Speaker, we look forward to the support on both sides of the aisle for this resolution. May it please you.
I rise to second the motion. In doing so, I would want to make one observation, perhaps two, which is to draw the attention of to paragraph 3, which says Saturday 18th. One of those two things is incorrect. Saturday is the 17th, I think. And so it is either Saturday. Oh, April, I'm sorry. I misread it. Okay. But I stand, Mr. Speaker, to support this because when you look at the resolution before us, given the decision of the court, there is no doubt that this emergency, this state of emergency can be extended for any period. And whereas some persons seem to have had the original impression that you had to have 1 year, certainly that does not now apply. And Mr. Speaker, the fact that we have a bill, the COVID bill, already read for a first time, being prepared for the Parliament within a reasonably short time, when I'm sure the more substantive debate will come on that issue. Having this motion ensures that there's no gap. There's no gap after the end of the period on the 18th. There is no gap between that time and the commencement of the COVID bill. While, Mr. Speaker, one might say we would not expect anything to happen between now and then, And while we do not expect that the COVID bill will go down to, that the emergency will go down to December the 31st, it is important for us to be guarded, be safeguarded by putting it down to the end of December, so that in the unlikely event something happens which prevents the COVID bill from being heard in a timely manner, say by the end of October or sometime in the middle of October, middle of November, then certainly this emergency will still be in place. Mr. Speaker, we have a state of emergency and nobody even feels as if there's an emergency. So we feel like the place is opened up already. And so I don't think that this is any onerous position being taken by the government. This is just a position of protection. Protection in the event something does happen before the COVID bill does come in place. For those reasons, Mr. Speaker, I have no difficulty, no reservations indeed, in giving support to this resolution. May it please you, Mr. Speaker.
Yeah. Permit me, Mr. Speaker, to rise to make some very brief observations regarding this bill, this SR&O, this resolution pertaining to the St. Christopher Nevis 1983 Constitutional Order, which is extending the existing state of emergency that has been imposed during the onset of the COVID-19 pandemic here in St. Kitts and Nevis. And, Mr. Speaker, I want to emphasize that even though the court today did not nullify the state of emergency as was sought by the court action of two former members of this assembly and myself, we still believe that the restriction that this bill brought to the opposition during the election campaign, and we wish that it would have been avoided because there was restriction. But, Mr. Speaker, and that is why I am uncomfortable with this resolution, because we still question whether it is absolutely necessary to remove, to restrict the civil liberties and freedoms of citizens of this country in order to be able to manage the COVID-19 pandemic as a result of the spread of the coronavirus. We believe that we can continue to prevent the spread of this virus and thus the negative effect of this pandemic through other legislation. For example, the COVID-19 Prevention and Control Bill 2020, which we had a first reading for this morning in this assembly. It is because of that uncomfortable feeling that I'm asking, why couldn't we have introduced this today, have its full effect as a means, as an instrument of controlling the spread of the virus, rather than having to resort to a furtherance of the state of emergency, which people are uncomfortable with, to the point where members of this assembly took the matter to the court for clarification. And so again, I am asking, why do we have to extend the state of emergency rather than using, not the Public Health Act, which is what we were saying then, but now you framed a COVID-19 Prevention and Control Bill 2020, which had its first reading today. Why not having had the opportunity to debate this, pass it, and then there might have been no need to again continue to withdraw the civil liberties and freedoms of the people of St. Kitts and Nevis. That is the concern, Mr. Speaker, which I wish to raise as we debate this particular resolution. Of course. Why not?
Thank you. Thank you, the honourable member for number 6, Dr. Douglas, Right Honourable Dr. Douglas. Any other contribution to the resolution?
Mr. Speaker, I know that we are still in the frame of resolving rules, but as mover of the resolution, I want to respond. And to point out that the state of emergency is considered a very serious and drastic thing. Under state of emergency, individual liberties can be suspended. This, however, in our case, had been done. Certain restrictions have been put in place through regulations under the Emergency Powers Act. The Emergency Powers Act has had a series of regulations promulgated by SRNO. We are, I think, right now up to 37, Regulation 37, where behaviors of our people were being modified for us to be able to protect ourselves and others. And so we recall that under those regulations, there was a lockdown. People were asked to stay at home, to stay in place. Total lockdown. That's a suspension of the liberties, individual liberties. And at the time, despite what the member opposite may have said, people understood and felt that it was necessary. In March 25th, 26th, 27th of this year, when there had been the initial 2 cases of coronavirus pandemic brought in by returning nationals who came back, there was deep concern, and it was heartening as a Kittitian and Nevisian to see our people adapt and understand that we could not afford to be exposed, have ourselves open to this sickness that we saw daily, nightly on the television, where people were dying around the world. Some of us, many of us will know of Kittitians and Nevisians who have passed away overseas from coronavirus. We saw the body bags. We understand, and we still hear of it, we understand that this is a very serious, a very deadly matter. And so when those regulations were passed, people were seen lining up outside supermarkets, physical distancing. Our people conformed and understood. They were prepared, understood and prepared to have the inconvenience of some of their rights suspended. And we went to 5 days. Sometimes you couldn't shop one side and then the other. But as our medical team has advised us to gradually relax those, the curfews, to, as it was, lift the suspension of those individual liberties and rights. We have been coming back to a sense of normalcy. Even with a state of emergency in place. States of emergency, Mr. Speaker, that occur in countries around the world, as we have seen it over time, tend to have a military component. Barricades, guns, where there's civil unrest. That's what we understand the state of emergency to be normally. There's a threat to life in a different way, from bullets flying. Even today we see protests in some countries in Eastern Europe, or war. In our case, as it is in most of the world, there is a fear, a deep concern, that if we don't have the tools to manage and control the transmission of COVID-19, it could affect some relative of ours, some person we know. There is a concern. The member opposite has said, well, we don't need it. We could use the Public Health Act or even our COVID-19 Act. The COVID-19 Act is not in place yet. We have had a first reading. And I'm not trying to be pedantic, but it gives time, hopefully over the next couple of weeks, few weeks, before we fully open, for it to be circulated and understood, not only by members of this Parliament, by the community at large. There are things that still are being worked on that we hope will have to be added to assist us. And the point I make, Mr. Speaker, is that there has to be a balance. There has to be a balance of weighing the risk of a transmission, of an entry of COVID-19 into our country against the potential for individual rights to be abrogated. The ruling today by His Lordship felt that that had not happened in our country, has not happened. Well, there's been no further challenge since, but that has not happened. That the state of emergency, and this is my interpretation, I have not seen the judgment, I've only heard an oral summary of the judgment to this point, but the oral summary would seem to suggest that at the time when this resolution was passed, that the state of emergency was reasonably justifiable in our democratic society. And there have been other judgments of this in Trinidad, where there has been a very long and extensive judgment on the same matter, where there the court found that within the context of the threat of this pandemic and the balance between individual rights and the protection of people from being able to contract COVID, that the court felt that the public health protections would be reasonable in our societies. I think that I understand when the member opposite said that he's uncomfortable Because at any time in a democratic society where someone has to have their rights suspended, there can always be that sense of being almost being made naked. But as we move to the opening of the borders on the 31st of October, there are a number of people, and I dare say maybe a majority of people in our community who are concerned as to what could happen to us. And what we are doing with the extension of the state of emergency, not for 6 months, as in the first time, but to enable to us to perfect the bill that was read for the first time this morning, to ensure that such protocols, some of which the Honorable Prime Minister, member for number 7, spoke to in his statement, such as the public health app that would allow those who come to St. Kitts and visit us to download this medical app onto their smartphones, to monitor their temperatures, any symptoms they may exhibit, coughs, temperature, any other symptoms are entered into this app that is hooked virtually real time with monitoring systems by our health teams, our medical teams, so that they can determine whether to do follow-up with these individuals. The app is being refined, but is quite comprehensive. We understand that is to be able to provide geofencing, so that where somebody should be in a bubble, should be confined to a particular area, but goes off the reservation, that there would be an alert. We also hope to have available, and we await determination by our health team, our experts, whether a bracelet should be worn that should have some chip or transmitter that can be picked up, again, for purposes of geofencing, for quarantine purposes. There has been significant work done by our tourism authorities, training of hospital staff. They continue to work with our taxi operators, tour operators. There are some limited tour sites that are being reviewed and being prepared as a bubble, so that people who may be high risk do not come into contact with the ordinary citizen. There are things that must be done over the next couple of weeks, few weeks, as we build this protection, this regime, this framework to protect our people. And protecting our people must be our number one concern. Has to be. But there has to be a balance, and we understand that we have to gradually expose ourselves to the opening up of the country to have people come in, some from high-risk locations. It is the first step, and we say that over the next few weeks, as we work to get it right, that the state of emergency that comes to an end expires, the resolution that expires on Sunday, be extended for a short period. The same one, nothing's going to change. The same regulations, nothing's going to change that we have had last week and yesterday and today. But there needs to be that framework in place for our medical personnel, our compliance teams to do their work even before we are able to complete this COVID prevention and control bill and make it into law. We understand the concerns, Mr. Speaker, but we believe in our country. We should protect our people, and the recommendations we have had is this is the best way to do so. There has been no challenge to my knowledge that anyone, well, I have to be careful how I say that, because there had been a challenge that it had been unfair to members of the Labour Party during the campaign. The court has said that that is not so. That nothing, no right that they had been abrogated, other than that to use ZIZ for a week or so before there had been a consent order for them to have access to ZIZ for free time and paid time, which they did have for the latter part of the campaign. Other than that, we have been told by the court that there had been that balance. Mr. Speaker, we hope that we can get the support of those on the opposite side. A short window, while we get it right. May it please you, Mr. Speaker.
Thank you very much, Honorable Attorney General and the mover of this resolution. Before I put the question, I think we need to make one slight amendment. There's a typo. It appears in the caption of the resolution with the word "and" coming between Saint and Christopher. So we need to delete that "and" caption. In the caption of the resolution, it reads Section 19, subsection 7 of the Saint.
I understand.
Yes, so just for the record, that is amended. Those in favor of that amendment? Those against? The ayes have it. Given that this type resolution requires two-thirds approval, two-thirds of the membership of the Assembly approving, we will have to do a poll, because that's the only way the chair can ascertain that we in fact have at least 10 members supporting the resolution. So, Madam Clerk, if you can conduct that poll, please.
Honourable Member for St. Christopher 1, how do you vote? Honourable Member for St. Christopher 2, how do you vote? Aye. Honourable Member for St. Christopher 3, how do you vote? Aye. The Honourable Member for St. Christopher 4 is absent. Honourable Member for St. Christopher 5, how do you vote? Aye. Honourable Member for St. Christopher 6, how do you vote? Honourable Member for St. Christopher 7, how do you vote?
Aye.
Honourable Member for St. Christopher 8, how do you vote? Honourable Member for Nevis 9, how do you vote? Honourable Member for Nevis 10, how do you vote? Honourable Member for Nevis 11, how do you vote? Honourable Attorney General, how do you vote?
Aye.
Honourable Wendy Phipps, how do you vote? Honourable Dr. Bernice Nisbet, how do you vote? Honourable Dr. Joel Clark, how do you vote? Honourable Speaker, I wish to report to the Honourable House that we have 2 members who have abstained. There are 11 ayes and 1 no, and 1 member is absent at this moment in time.
That being the case, the resolution to extend the state of emergency from the 19th of October 2020 until the 31st of December 2020 has been approved by this National Assembly.
Adjournment.
Mr. Speaker, I rise on the adjournment and ask that the Parliament be adjourned sine die. Recognizing it's already going for 8, I will reserve any comments I have to make.
Sorry, if I may make a very brief statement on the adjournment. May I? Yes. Okay. Mr. Speaker, October is a very special month as outlined by the Honourable Member for number 3. And it's special not just because of the breast cancer awareness. Last week, I think we celebrated Mental Health Day. And October is also Domestic Violence Awareness Month. And it is on this matter, Mr. Speaker, I'd like to mention that in relation to COVID-19, domestic violence in the Caribbean, in St. Kitts in particular, is becoming the shadow pandemic. St. Kitts Nevis, sorry. We have increased numbers of domestic violence reports for women and men who have to deal with abusive partners. And I think it's important that we bring further awareness to the importance of providing safe opportunities, safe havens for women and men, in particular women who have to deal with domestic violence. And it is in this light that I really hope that we can all support non-profit, non-governmental, non-political organizations which actually try to make a dent in the domestic violence situation. And as I speak, Mr. Speaker, what comes to mind is Garden of Rebirth, which is headed by, I think, Ed Subrachi-Keynes. And I think honorable members in this House had the opportunity to visit Garden of Rebirth. I myself, when I went there, it's a safe haven, it's civil social action, providing opportunities for women to escape abusive situations, especially when there's financial dependence. Garden of Rebirth actually has a livelihood opportunity for women, and I myself, when I went there, I actually got an item from their thrift store. And I actually word to Parliament the last time we were here, Mr. Speaker, just to help support women who want to create their own livelihoods when they're dependent financially on an abusive partner. And so kudos to the government for actually beginning the conversation on formalizing its relationship with an institution like Garden of Rebirth, which is, I think, one of the only institutions here in St. Kitts and Nevis which is directly addressing domestic violence. And I know there are other community groups and civil organizations like the Business and Professional Women, which are also trying in their own way to support women, women's empowerment, and to help women who need their own independent livelihoods away from abusive partners. So kudos to the government for beginning the conversation to formalize these working relationships. And I hope that in the budget address, we can hear something very specific about the response and the monies that would be budgeted for responding to domestic violence. And perhaps we can deal with the Domestic Violence Act soon enough. Thank you, Mr. Speaker.
Mr. Speaker, I rise to make a very, very brief contribution on the adjournment. I remember my first presentation in Parliament. I said I would not be on the opposition side just to be opposing, and when credit need to be given, I will do it. And it is quite fitting that I commend the cleanup crew in East Bastia in particular for the outstanding work that they are doing. And I think alongside with Parks and Beaches, I would have had a similar conversation with Mr. Nisbet, because as I visit residents, especially in the Frigate Bay Half Moon, they would have been complaining about the trees coming over in the road, and I was happy that I was able to get some of those done. In addition to that, Mr. Speaker, there are a number of street lights that would have been out in particular areas, Frigate Bay again, for quite a while, and I was able to get Skelec to assist in this regard. So I think it is only fair to thank those who were responsible, Mr. Speaker. And Mr. Speaker, while we are in this mode,
because the representative for that area brought it to my attention. You have to tell the truth.
Mr. Speaker, on Tuesday, Ms. Ruby Thomas of Pickens Street will be celebrating her 100th birthday. So I would want to use this time to wish her advanced birthday greetings. You would only imagine that at 100, it is something to celebrate. Usually the social development department, they also join in that celebration, and I'm looking forward to that. And my young group, or my youth in the constituency, on the weekend they are doing a project in terms of doing a whole makeover, so I'm looking forward to that. But I wanted to wish her the very best, and may God continue to give her that life until whenever. I mean, you never can tell, Mr. Speaker. So we are excited in East Bastia that we'll be celebrating. And shortly after Parliament, Mr. Speaker, I run to a youth forum organized by the Sniper Group. And I want to take this opportunity again to wish them the very best as they are celebrating their 19th anniversary. A group that I started, and I'm extremely proud of the work that they're doing. May it please you, Mr. Speaker.
May it please you, Mr. Speaker, I rise very briefly on the adjournment to report to this Honourable House that after discussions and meetings between your Honourable Office and the Department of Youth, the Cabinet has approved and agreed to the hosting of the special sitting of Parliament, as has become customary over the past few years, to acknowledge the 25 most remarkable teens. The date that has been agreed to is November 19th, Thursday, November 19th, and the venue will be at the Rivers of Living Water Christian Center, at Lime Keel here in St. Kitts. And so I wish to advise all the members and by extension those who are listening. May it please you.
Thank you very much, honorable members, for those brief presentations on the adjournment. This honorable House stands adjourned sine die.